I also wanted to say a quick word of thanks to Human Rights Watch, our co-sponsors, and in particular, Sarah, who you've seen up here all morning. And it's really because of Sarah's deep knowledge of and commitment to these issues that we've been able to put together such an incredible group of speakers today. So it's just been wonderful to work with her. At this point, I'm very pleased to be able to introduce our lunch speaker, Arry Nyer, who, as most of you know, is president of the Open Society Institute, and as some of you may not know, is also visiting here at Georgetown Law this semester as our Robert F. Drinan, S.J. Visiting Professor in Human Rights. For those of you who are based here in D.C., I should also mention that we're keeping Professor Nyer very busy these days, and he'll be giving another talk tomorrow afternoon from noon to 1 in our library that's going to be called The International Human Rights Movement, Its Successes and Failures. So for those of you who are around, I would invite you to join us for that as well. Arry Nyer is, as most everyone here knows, a true pioneer of the human rights movement, having served in top leadership posts in 3 of our country's most influential human rights organizations. He was executive director of the American Civil Liberties Union, co-founder and executive director of Human Rights Watch, and now president of the Open Society Institute. He's made his mark in a staggering range of substantive areas, from women's rights to the rights of persons with disabilities to, of course, the area we're discussing today, accountability for war crimes and the challenges of balancing peace and justice. Arry Nyer began to focus on international accountability as early as the 1980s through his work in Argentina and Chile, and even then he was a forceful advocate for the position that society must hold perpetrators of grave crimes accountable for their actions. Just 3.5 months after war broke out in Bosnia, he called for the establishment of an international criminal tribunal for Yugoslavia, and in the years since then, he's been a strong advocate and defender of the ICTY. And in recent years, through his work with the Open Society Institute, he's continued to assist individuals and groups that are pushing for accountability before mechanisms such as the ICTY, the ICTR, the Special Court for Sierra Leone, the ICC, and elsewhere. In addition to leading 3 of our country's leading human rights organizations, Arry Nyer is also a prolific writer. He's written 6 books, one of which, entitled War Crimes, Brutality, Genocide, Terror, and the Struggle for Justice, devotes an entire chapter to the trouble with amnesty. And another one, his most recent, which is entitled Taking Liberties, 4 Decades in the Struggle for Human Rights, includes a fascinating chapter about his work promoting accountability. He regularly contributes to the New York Review of Books, and his work has appeared in the New York Times Magazine, the New York Times Book Review, and Foreign Policy. For about a dozen years, he also wrote a column on human rights for The Nation. We have been really honored to have him visiting here at Georgetown Law this semester as our Drinan professor, and I know that the students who are in his class, which is on the practice of human rights, have learned a tremendous amount from him. So with that, I'd like to now turn this over to Arry Nyer, who will offer his thoughts about the challenge of balancing peace and justice in a number of different countries and contexts around the world. Thank you.
Thank you very much. Those of you who have been here this morning, I think, are well aware that these questions of peace and justice arise with some frequency. Certainly they have arisen constantly in the period starting in 1993, when the first contemporary international tribunal was established to deal with war crimes, crimes against humanity, and genocide. That is the International Criminal Tribunal for the former Yugoslavia. And as Judge Goldstone said this morning, the issue arose particularly in 2 instances in connection with the Yugoslavia Tribunal. One was, as he mentioned, his indictment of General Mladic and Radovan Karadzic at the time of the Dayton peace talks, after previously having indicted both of them. But the indictment at the time of the Dayton peace talks seemed to be a kind of signal to the international community that the question of justice was not going to go away during the peace negotiations. And also, as he mentioned, it arose again at the time of the war in Kosovo when Judge Goldstone's successor indicted Slobodan Milosevic. I think one of the things that stands out for me in considering those two episodes is that there were a lot of predictions that were offered, and I don't recall anyone getting it right. That is, there were lots of people who said that the indictment of Karadzic and Mladic would prevent successful peace negotiations, that the prospect of prosecution had to be dropped in order to make the negotiations successful. But I can't remember anyone at that time, and I was observing what was taking place quite closely during that period. I can't remember anyone saying that, in fact, the indictments would enhance the prospect that a peace negotiation at Dayton would be successful. Certainly Richard Holbrooke, as the negotiator, didn't think that it would make his job easier at Dayton to negotiate a peace agreement. And Judge Goldstone referred to Viktor Chernomyrdin, the Russian prime minister. Actually, Chernomyrdin made a public statement saying that the indictment would make it impossible to achieve a peace negotiation or a peace settlement with respect to Kosovo. And it was just 1 week after his public statement that Milosevic agreed to a peace settlement with respect to Kosovo. Chernomyrdin is a smart man, a politically sophisticated man, and yet he was completely wrong in his estimate of what would take place. And there's a lesson that I would derive from that, and it's a lesson that has been repeated in other circumstances. And the lesson is beware predictions on this matter. They're speculative, and the track record is not one which inspires confidence in the ability of people who are astute politically to be able to judge which way the process of justice is actually going to affect what happens in a peace agreement. David Crane referred to the Lomé peace agreement, and he referred to the role of Francis Oquilo, who was the representative of Secretary General Kofi Annan, who put that line in connection with his signature on the Lomé peace agreement, saying that the amnesty which was agreed to in the Lomé peace agreement does not apply to international crimes. One might have thought, or one might have guessed, that this would upset the possibility of a peace agreement. It did no such thing. And it made it possible for the Sierra Leone tribunal to go forward. When the indictment of Charles Taylor was made public, it was suggested that Taylor then would have additional reasons to hold on to power in Liberia, but it was just 2 months thereafter that he took refuge in Nigeria. And David Crane said that there is today a peaceful and democratic government in Liberia. One could add there is a peaceful and democratic government in Sierra Leone. Both countries suffered tremendously from the conflicts in which Taylor played a central role. And both countries are doing quite well today in terms of their effort to recover from the horrendous human rights abuses that took place in those two countries. We've heard discussion today of the International Criminal Court, and again, I want to cite something which, so far as I know, no one predicted. You know that the Rome Treaty for the International Criminal Court was adopted in July 1998. And it was then predicted that it would be a long period, at least 5 years, before the necessary 60 ratifications were obtained to allow the International Criminal Court to begin operating. It was going to take that long because a number of countries had to make constitutional changes in order to ratify the treaty for the International Criminal Court. As it happens, it progressed somewhat faster, and the necessary number of ratifications was reached a little less than 4 years after the Rome Treaty was adopted. The day was actually April 11, 2002, and on that day, 10 countries ratified the treaty for the International Criminal Court. I suppose that each of them wanted to be the 60th government to allow the treaty to go into effect. But by the end of the day, in fact, there were 66 ratifications of the treaty for the International Criminal Court. And one of the ratifications came from the Democratic Republic of the Congo. And the DRC ratification was faxed in to the United Nations, and the United Nations accepted the fax as an indication that the DRC had ratified the treaty. The treaty then would go into effect July 1, 2002. And since the treaty for the International Criminal Court provides that its jurisdiction is only prospective, it would only be crimes committed after July 1, 2002 that could be prosecuted before the International Criminal Court. So there was a period of 2.5 months between the necessary number of ratifications and the date when crimes could be committed that could be subject to prosecutions. Quite a remarkable thing happened during that 2.5-month period, and again, no one I know predicted this. During that period, 5 other African countries which had armed forces in the Democratic Republic of the Congo all withdrew their armed forces. That is, Rwanda had gone into the Congo to chase the people who had fled into the Congo and who had committed the 1994 genocide in Rwanda. Uganda was allied with Rwanda. And on the other side, there were Angola, Namibia, and Zimbabwe. They all rather profited from their presence in the Democratic Republic of the Congo. because the Congo exemplifies, perhaps more than any other country in the world, what is referred to as the resource curse. That is, it has so many natural resources, it is cursed by them, and the 5 different armies from 5 other African countries were harvesting the natural resources of the Congo, and the 5 governments that had sent troops into the Congo were all deriving a very substantial profit from the rich natural resources of the Congo. And yet none of the heads of state and none of the military commanders who were in the Democratic Republic of the Congo wanted to be the first to be prosecuted by the International Criminal Court. And so they withdrew their forces. Among other things, they could have been prosecuted for the crime of pillage, which was a lot of what they were actually engaged in the Congo. But they withdrew their forces. The Congo hasn't exactly been at peace since then. There have been warlords in the Congo who have continued combating each other. But it was a big step in the right direction to get those 5 other armies out of the Congo. And so the International Criminal Court, by coming into being and by having the possibility of bringing prosecutions in the Democratic Republic of the Congo, happened to contribute to peace, something that no one that I know managed to predict. So the lesson I derive from this history is, again, be very skeptical about the predictions you hear. They might be right, but they might not be right. And so far, those who have engaged in the predictions haven't demonstrated by their record that they are right in predicting a conflict between doing justice and making peace. Now, the other thing that I would say is that there are certain circumstances in which people have made compromises with respect to justice in the interest of peace. And as I look back on those circumstances, there is at least one such case where I think if I had been in the same position, I probably would have made the same compromise. And this doesn't arise in the field of international justice, but it does involve a transition in one country. And here I refer to South Africa. In the South African case, there was a certain point at which the nationalist government had indicated in its negotiations with the African National Congress that it would not agree to what became a largely peaceful transition. It would not agree to a transition unless an amnesty was provided for those who had committed crimes in the service of the apartheid state. And as a consequence, an amnesty provision was incorporated in the temporary constitution under which the transition took place. And if I had been in Nelson Mandela's shoes, I think I probably would have felt obliged to make the same decision that he made. The importance allowing a peaceful transition to go forward at that moment did indeed seem to me to be paramount. And yet, the story doesn't end with the temporary constitution and its amnesty provision, because South Africa did create its Truth and Reconciliation Commission, and an official who was committed to the idea of accountability made the best of the amnesty provision. The official was Dullah Omar, who was the first Minister of Justice in the South Africa in which Nelson Mandela was president. And Dullah Omar proposed that amnesty should not be provided collectively. It should only be provided individually. It should only be provided to those who acknowledged their crimes and fully disclosed their crimes. And so there had been truth commissions in quite a number of other countries before the establishment of the South African Truth and Reconciliation Commission. But that commission proved to be a more valuable body than any of the commissions that had preceded it. I think there were a number of reasons. One reason was South Africa had tried to preserve a facade of legality during the apartheid period, and I think the commission helped to penetrate that. I think another reason was that unlike the practice in Latin American countries up to that point, in which hearings were held behind closed doors, in the case of the South African Truth and Reconciliation Commission, the hearings were public. But I think the most important factor was that question of making amnesty individual rather than collective, because it meant that officials who had engaged in crimes themselves had to come forward and acknowledge and fully disclose their crimes in order to qualify for amnesty. And there was really nothing we had seen previously that compared to those who had engaged in torture, for example, coming forward and demonstrating the techniques that they had used to engage in torture. They faced the choice of either disclose or acknowledge and fully disclose, or risk the possibility of prosecution. And the lesson I derive from that is even when one feels obliged to sacrifice the possibility of justice, it may be possible to still do something which achieves a measure of justice. Would I rather that those who committed terrible crimes should be prosecuted for the crimes? Yes. But given the possibilities in the South African case, it did seem to me that the government of Nelson Mandela, led by its Minister of Justice, had made the best of a situation by still striving for a method to render justice. We've had other situations in Latin American countries, and in Latin America, what has taken place is that justice was not done at the time of various transitions, or it was only done in a very limited or partial way. But justice delayed is not only justice denied. Justice delayed may be a very significant measure of justice. In the case of Argentina, when Raúl Alfonsín became president in 1983, he had set in motion the Truth Commission, which became the model for such bodies in other countries, and he had also launched a justice process. And in one trial, 9 members of the first 3 military juntas that had ruled Argentina during the military dictatorship were tried, and 5 of them, including 2 former presidents of Argentina, were convicted in those trials. And a small number of other trials were held. But at the point that the Argentines started to try middle-level military officers, they rebelled. They had only been following orders, they said. It was the top generals and admirals who were exclusively responsible for the crimes. And the Alfonsine government put down more than one rebellion of the military officers, but it also adopted measures that required that those who had been following orders, that is, they called it a due obedience law, would not be subject to prosecution. And they also adopted a law placing a full stop on the trials. And then Alfonsine's successor ended the process entirely, pardoning those who had been convicted and issuing an amnesty. But today, many years later, with the Inter-American Commission on Human Rights having quite a long time ago declared the amnesty invalid, there are prosecutions going forward of the people who committed great crimes during the period of military dictatorship. And there are hundreds of Argentine officers facing criminal charges today or convicted of criminal charges and serving prison sentences. Something similar is taking place in Chile. After the Pinochet regime came to an end in 1990, there were no prosecutions in Chile. But today, again, hundreds of military officers are facing prosecution or have been convicted and are serving prison sentences for their crimes committed during the Pinochet dictatorship. In the Chilean case, it was the case against Pinochet that was brought in Spain and that resulted in his arrest in London that broke the ice and allowed prosecutions to go forward in Chile. So Argentina, Chile, South Africa suggest to me that even though there are times when it is difficult or impossible to press for justice at a particular moment, one doesn't have to abandon the struggle for justice. The struggle for justice can take different forms, or it can resume at a later period. In general, I would say that as we think about the idea of peace and the idea of justice, I think we are best off separating them. Each has its own importance. One should not be seen as instrumental in favor of the other. We should pursue justice and we should pursue peace. They should be pursued independently because of their intrinsic significance. There will be times when there finally does seem to be a conflict, but the conflicts will not be as frequent as is suggested. One should avoid reliance on those who offer facile prophecies about what is going to take place. when one comes right at it, the way in which Mandela came at it in the negotiations for the transition in South Africa, it is possible that one may have to give way for a period, but that doesn't end the effort. In my view, the effort to do justice ought to continue, and it certainly should not be swayed, it should not be deterred because of political predictions by people who turn out not to be very good at getting this right. Thank you very much. We don't have much time, but if you want one or two questions, okay. All right. Okay. Thank you.
I said, sorry, I lost track of time. Thank you so much. Thank you so much. And if I could invite the speakers for panel 3 to take the stage, that would be terrific. Nice to meet you. Thank you for being here. Thank you. Did you guys discuss amongst yourselves what order? Okay.
Mark and then Rupert.
Okay. If you guys would try to speak right into the microphones, we had some trouble hearing.
Ready?
So we do have until 2:30, yeah?
Until 3:30.
3:30. Yes, of course. Yes, 3:30. Where am I supposed to actually sit here? Here.
You're right here.
Thank you.
Oh, thanks.
Carrying a laptop everywhere means that there is always the need to then
Hide it
somewhere.
Yeah, I know.
Yeah, but why don't you leave me on there?
So should we get Mark?
That would be great.
Our coffee break between the different things to get everyone just.
Indeed.
You're too kind. But call me, and I'd love to talk with you more about that. All right. No, I know. They're actually quite draconian, which is fine.
Can I move over one?
So, not right now.
No, something is not on the bio, which is the ICTY. At least this is here. This is one which is the ICTY. You would be trying to hide it.
The ICT?
Yes. Because I thought actually at some point you had been with Joanna, okay, in Joanna's team, no?
No.
Okay, so
But you can say whatever you can say.
Johanna Corner actually is the one that
You can say whatever you'd like. So you can make up stuff.
Johanna Corner. When I was reading to her, she said, when there is more, do you remember when you was reading to her? She's like,
I don't think so. I'm happy. I'm conjuring up fantasies in people's lives. That's not what I've actually done.
I was so
No, you just stick with the script.
so convinced you had been at the SHY.
No. Mostly all just Rwanda stuff. But anyway, but thank you for asking.
So are you in DC?
Hello?
You don't miss this area.
Good afternoon. Good afternoon. My name is Cécile Abtel, and it's a real honor to be here this afternoon. Thank you very much to Georgetown Law, and in particular to Rachel Taylor and the Georgetown Human Rights Law Institute, as well as thank you to Sarah Darishari, my good friend from Human Rights Watch. After having had two absolutely outstanding panels this morning discussing peace and justice, and after having heard the remarkable speech by Arry and Nyer, where we finally understand that justice has to be pursued for the sake of it. And in fact, I'm saying that jokingly, but clearly what we're going to now do is to concentrate on the issue of justice in this panel, and to really look at how do we actually do justice, and to look at how much justice needs to be done for building solid foundation for peace to prevail. And in this context, we are also going to try to look at the ways in which justice can be fostered. To do so, we have a great panel here this afternoon with Mark Drumball, who will start. Mark is a professor of law and director of the Transnational Law Institute at Washington and Lee University School of Law. And he is also the author of a book entitled Atrocity, Punishment, and International Law. After Mark, we will have the remarks by Rupert Skilbeck. Rupert is the litigation director for the Open Society Justice Initiative in New York, and he has a vast experience in the defense of accused before international and hybrid courts, notably as the former principal defender of the extraordinary chambers in the Court of Cambodia, as well as in similar positions in Sierra Leone and in Bosnia-Herzegovina, before the State Court of Bosnia-Herzegovina. And finally, we'll hear Adam Smith, who is currently an associate at Covington and Burling, and is the author of a book which is called After Genocide, Bringing the Devil to Justice, which is a very clear title, and also the co-author with Richard Goldstone of a book entitled International Judicial Institutions, The Architecture of International Justice at Home and Abroad. And with these three gentlemen there, maybe just to introduce the topics that we could have in this panel, I think it might be useful to look at how domestic accountability can be triggered and fostered, notably in relationship between domestic courts and international criminal jurisdictions. And in particular with the International Criminal Court. We have talked quite a bit about the International Criminal Court today and the complementarity principles that foresees that only if states are unable or unwilling to do justice can the ICC operate. Now, what does that really mean in practice? Is there a role for the International Criminal Court to trigger domestic jurisdiction, concretely by pushing them, by advocating for domestic accountability? The recent case law developed by the International Criminal Court shows that the ICC is looking at what states do on a case-by-case approach, rather than assessing more generally whether a country is furthering accountability. The ICC judges assess whether, in a specific case in which the ICC is interested, whether in that specific case domestic accountability is being furthered. What are the implications, maybe, for furthering and fostering domestic accountability? And then maybe we could also, and probably more crucially, look at how concretely can domestic accountability be furthered in domestic context, in post-conflict setting. what we see far too often on the ground is that there is not necessarily the political will to foster accountability in post-conflict situations. In a vacuum of political will, is there any way that the desire, the wish to foster accountability for grave crimes can be triggered by outside sources? What can they be? So-called friendly governments? Possibly some form of wish to join a certain group, and I'm in particular thinking of the impact that the European Union has had in the Balkans, in many countries trying to join the European Union, and that have therefore seen the conditionality set forward by the European Union as way that pushed them into furthering accountability. But generally and ultimately, justice is really a fundamental state attribute. And it is a fundamental, it fundamentally impacts on the issue of sovereignty. And states are very keen to insist on their sovereignty, and criminal justice is such a part of that sovereignty that how much can we really expect from pressure from outside sources? And just one last point maybe that I would like you to address. It's the need to remain comprehensive when we're trying to foster accountability at the domestic level. And in particular, that needs to be comprehensive can be meaning that we should look beyond just the category of war crimes, crimes against humanity, and genocide, or should we restrict ourselves to those three categories of grave crimes, of grave human rights violations? One category is there in the background, I would argue, and that's corruption. Far too often in post-conflict setting, we see corruption as a threat, in fact, to stability, and very much as a huge impediment in the pursuit of criminal justice. And another area in which we may need to be comprehensive has to do with the understanding of what is criminal justice. Can we ever look at criminal justice and at fostering criminal prosecutions in the absence of much broader institutional reforms? And then in particular, whether, we as lawyers always want to think that we can do it all on our own, but can really any prosecution be triggered without very serious investigations? And then can you have ever any serious criminal investigation in the absence of a reformed police? And so what does that really highlight in terms of relationship between criminal justice but broader reforms in terms of security sector reform, police vetting, and other institutional reforms? So with such an agenda, Mark, if you could please take the floor.
Thank you, and good afternoon to everyone. It's really been a fascinating day. I've learned a lot, and hopefully both learning and fascination won't cease now that I've opened my mouth. So let's forge ahead and continue to think through some of these particular challenges of balancing peace and justice. And I think it's wonderful that the organizers have put together a day for us to think about this, because I believe in thinking about it, there's one very refreshing thing that I feel has emerged, and that is this. Our thinking has become infinitely more sophisticated and nuanced over time. Much critique has become mainstreamed, and at the end of the day, I'm gratified to see us eschewing purism and often a binary reductionism of good, bad, peace, justice, evil versus impunity within the overall framework. And I think with our field maturing in this particular regard, I hope that new market entrants into our field, like many of you out there, will enter an area in which the conversations are going to be a little more informed and perhaps a little less forceful. At the end of the day, there's a rule for criminal law in building rule of law, and there's a role in that particular capacity, and that role is very critical. Of course, I believe law is no savior. I personally think the role of criminal law is and should be quite modest in the overall process of transitioning past episodes of massive violence. And to some degree in my writing, I have worried and fretted about the extent to which the atrocity trial has become deployed to define the consciousness and the public imagination of what justice means and ought to look like. And to some degree, the atrocity trial has emerged as the first best response to systematic abuse and violence. And as a result, courthouses and jailhouses have emerged as the preferred architecture of dealing with this systematic violence. Instead of searching, in my opinion, for parsimonious solutions, I believe we should revel in the complexity, the messiness, and the hard work that's required to transition societies beyond periods of massive violence and deter those in the future. And as a result, the other thing we should revel in, I think, is modesty with regards to the transformative role of law. Today, our conversation has focused on international criminal justice institutions, and in particular, high-profile defendants in front of international criminal justice institutions. And that's a very important conversation and a key conversation, but yet I do feel that to some degree, international criminal law as operationalized in international institutions tends to attract a disproportionate amount of intellectual effort, resources, thought, and creativity. And a lot of the work on the ground of dealing with issues of peace versus justice, I believe, happens within a broad variety of national institutions, many of which don't even necessarily look like criminal trials. And I think what I'd like to do in my remarks is talk about three areas that are a little off the beaten path, not in terms of how people lead their lives, but in terms of general conversations in which discussions of peace versus justice are critically important and to some degree, I believe, under-actualized and under-thought of. And I want to pick up on one quick point that you mentioned in terms of what is often important for victims, I think, following systematic periods of violence. I don't think we can underestimate also the importance of things like property crimes. I think in a lot of my work with victims on the African continent, routinely property crimes become discussed as an important element of transitional justice. And I feel that the extent to which that corruption, these other forms of atrocity and instantiations of it are overshadowed to some degree by the most egregious cases presents an incomplete conversation to some degree. So what are the three areas I want to talk about of balancing peace and justice? Here are the three. First, DDR programs, disarmament, demobilization, and reintegration programs. That's something we haven't talked about much today, and I'd like to introduce those and also suggest that to some degree they present one area where proponents of peace have actually done quite well in terms of dominating the overall framework of DDR programs, to the extent to which many DDR initiatives do not incorporate transitional justice or accountability mechanisms. The second area that I'd like to look at are immunities. Now, not just immunities in high-profile cases or the non-existence of immunities in high-profile cases, but immunities, for example, in civil lawsuits, potentially arising through universal jurisdiction, a question that I believe the United States Supreme Court is about to hear in the Samantar case, the question as to whether the Foreign Sovereign Immunities Act, for example, applies to individuals who are defendants in Alien Tort Claims Act litigation. I think immunities represent an important instantiation of the peace versus justice conversation. And finally, another area, if we take a slightly more robust view of peace and to some degree understand it as also including issues of comity among nations, one area that I think is extremely interesting is the intersectionality of peace versus justice in extradition law. What we're seeing emergently, I think, and with Rwanda, I think is a very important example, the conversation as to whether individuals ought to be extradited, for example, back to Rwanda to face criminal process there. And we see in a variety of case law, particularly coming out of the European and the UK context, interesting conversations about how fair trial rights, often, at least in the Rwandan context, put into play by referral decisions involving the ICTR internally, is now beginning to bleed over into questions of extradition. So I think these are three very disparate areas that I think could seed a very important conversation about what peace versus justice looks like outside of the formal context of international criminal trials. So let me take a couple of minutes on each, and I hope, at a minimum, trigger a conversation about what peace versus justice may look like in different contexts. And I think in this regard, it's important to keep in mind one overarching question, and that is this. Is the relationship between peace versus justice necessarily static, or does it take different forms depending on the players involved? In other words, are trade-offs, if there are any, less with regards to certain defendants or certain kinds of perpetrators, or greater? And I think if we assume that peace and justice can comfortably coexist at certain levels of potentially high-profile defendants, I don't know if that's always clear further down the line in terms of different kinds of defendants. So let's look at DDR programs. One of the most favored methods of conflict resolution is simply to encourage the disarmament and demobilization of former fighters, many of whom commit systematic human rights abuses in the context of their particular conflict. And although the D and D parts, demobilization, disarmament, have actually worked relatively well, the reintegration element, the R, has been somewhat more complex in the context of many post-conflict societies. A lot of reintegration is premised on the following notion, that any form of accountability can be injurious to the reintegration of former fighters into the communities where their abuses may have been committed. And to some degree, a lot of international humanitarian and human rights organizations now are becoming quite interested in the question as to how does reintegration work in this particular regard. And moreover, many former fighters often receive cash benefits or other forms of assistance as part of reintegrating and encouraging the cessation of hostilities. Now, on the one hand, there's some evidence that what one ethnographer in the context of child soldiers has called doctrines or notions of abdicated responsibility or discourses of abdicated responsibility. On the one hand, these may facilitate reintegration, but on the other hand, the absence of transitional justice and accountability for many former fighters has actually led to, in some instances, persecution, ostracism, marginalization, and community tensions, especially when the former fighters receive benefits that many of their victims don't necessarily receive. The fact that some of these conversations arise in the context of child soldiers, I think, has given an out to asking hard questions about agency, responsibility, and reintegration. But yet, if we're really going to talk about peace versus justice, it's one thing to talk about it with Milosevic and Taylor and al-Bashir. But at the end of the day, tens of thousands, hundreds of thousands of former fighters, many of whom are affiliated with groups that commit systematic abuses and themselves have done so, largely have become reintegrated without justice. And at the end of the day, I think it is important for us not only to learn more about whether or not that is successful, but also to recognize that, as with all post-conflict initiatives, the response is somewhat complicated and muddied. And the extent to which, I believe, we focus the conversation on selective, specialized justice, we should not divert our attention from these large numbers and issues of breadth of justice in these particular contexts. And I think it's important to frame DDR in these exact same debates that we frame Taylor to some degree. Secondly, immunities. What do we do about a situation when universal jurisdiction is pursued either criminally or civilly, and then individuals raise as defenses that they ought to be immune in large part because of their status, their position, or the fact that their immunity is central for them to have relinquished power or to have developed some kind of an overall political settlement. And I think it's important to phrase immunities conversations outside of the context where the question has been answered at the high-level international criminal justice institutions where there is none, within the framework of an increasing array of lawsuits where victims pursue justice often because they believe that amnesties or immunities that may have been granted are themselves unjust. And we see that emerging, and I think a fertile area for that is Alien Tort Statute or Alien Tort Claims Act litigation in the context of the United States. And I think framing those particular debates within the broader nexus of peace versus justice gives rise, in my opinion, to a very important conclusion, and that is piggybacking off of what other speakers today have said much more eloquently, namely, you can't necessarily define law by polling or by assessing victim preferences, because victims, in my experience, want a broad array of many, many different things. So I think we need to develop perhaps a more fulsome normative basis in which to flesh out peace and justice tensions with this kind of litigation. And finally, the tension between comity among nations on the one hand and justice on the other. So, for example, in the Rwandan context, in April of last year, the United Kingdom, the High Court, refused the extradition of 4 Rwandans back to Rwanda, there to face genocide prosecutions because of concerns over lack of due process, fair trial, and judicial independence in Rwanda. And that particular court relied quite heavily on Rule 11 bis judgments within the context of the ICTR itself, and to some degree externalized an administrative decision, namely, what are the rules that the ICTR has to satisfy itself are met in order for it to complete its completion strategy, and extended that to the context of interstate extradition under extradition law, which promotes a much broader array of political goals, namely comity among nations and to some degree deference to international executives. And a question that I have here that is very interesting to me when we consider those balances within that particular framework is this. Is it appropriate for us to place is it appropriate for us to say, hey, extradition law geared towards sending, suspect A or convict A in one country to another place to either face prosecution or serve sentence, we have to be guaranteed of certain due process requirements. Is it appropriate to extend that, which arises in the framework of ordinary common crimes, to the much more complicated framework of transitional justice, in which concerns over prosecution, justice, and national authority are very different than in the framework of sending an ordinary criminal defendant from place A to place B? We may come out in the same position. We may come out in the same result and say, no, we're not going to send these individuals to Rwanda for the exact same reasons. But I believe that the sui generis nature of transitional justice for massive atrocity ought to structure the conversation somewhat differently, ought to create a different template, a different nexus of conversation, and a different lens, that at least in this one particular case, or in others arising out of the European context, has not yet entered. So at the end of the day, to sum up, the challenges of peace versus justice take multiple forms, emerge through multiple discourse and multiple contexts. And I believe that it's very important when we talk about the existence or non-existence of trade-offs, that we move beyond the selective justice of international criminal tribunals, which is a necessary starting point for the conversation, and in fact generated the conversation in the first place, and is the level at which the most sophisticated analysis has been done to date. But I believe that the real future challenge is reaching down into these other areas. I've mentioned 3. There are probably dozens more. And investigating, opining, assessing, and reflecting on how peace versus justice debates actually touch the vast majority of people who are implicated in systematic atrocity, who come nowhere near international criminal tribunals. Thank you.
Thank you very much. The subject of this panel is entitled Building Firm Foundations, and I'm going to speak to 2 aspects of that. Firstly, the importance of building firm legal foundations rooted in human rights law when creating a domestic war crimes system. And secondly, the importance of firm foundations for practical matters so as to ensure that it's possible to have a fair trial. These are often aspects that are not properly dealt with. I'm going to speak from the perspective of the defence. The defence is not often represented in conferences to speak with a firm voice, but it's important that it's there. One of the roles of the defence is essentially to keep a check on the prosecution and the judges to some extent by testing the arguments and looking at what is going on with a sceptical, hopefully not cynical, perspective. By doing so, we hope to keep prosecution honest to the extent that that's required to be done. So one should challenge the accepted wisdom that often comes from the United Nations and other organisations with firm opinions on how to run war crimes tribunals. One of the problems with working with the UN is getting used to the jargon that is historically and traditionally used. My background is as a criminal lawyer in the United Kingdom, and we tend to speak rather bluntly in the criminal courts. And I was trained by a lawyer from Yorkshire in the north of England, where they speak more bluntly than anyone else. But having moved to the United Nations, I had to learn to use jargon. Very dangerous when translated. One of the most dangerous ones I heard was in a meeting in Cambodia where someone sought to translate the phrase gender mainstreaming, and it came out in the Khmer language as women swimming in the middle of the Mekong. So the two pieces of jargon that I'm going to use to address the two issues that I've looked at are firstly the highest international standards, and secondly the need to build capacity. Why are these important? Because at this stage in the history of international criminal justice, we're moving from the phase of international tribunals and hybrid, internationalized, whatever you care to call them, and we're moving to a period where there will supposedly be the ICC and then domestic trials. Now, many of those domestic courts will almost certainly have to have some form of international assistance in order to make sure they work. So we must look to what we've learned from the hybrid tribunals to see what the best way is to give that support to those domestic trials. So the first issue, the question of building firm legal foundations rooted in human rights law. Described often as the highest international standards. I always get very worried when a diplomat or a politician starts referring to the highest international standards, and even more worried when the prosecutor starts using the phrase, because it normally means he's going to take away something that your client would quite like to have. The problem with human rights law is one has to remember that it is a floor, not a ceiling. Human rights law represents the lowest common denominator, below which fair trials may not fall. It isn't an aspirational value. Fair trial standards in most countries should be much better than the standards that are guaranteed by human rights courts. An example, it's only last year that the European Court of Human Rights, one of the most effective of the human rights courts, decided that in fact you do have the right to a lawyer when you're first arrested in a case against Turkey. You may think that's normal if you come from a common law country. Don't get arrested in France when on your holidays there, because you won't have the right to see a lawyer for the first 48 hours that you are in detention. So that is a very dangerous thing to just import some international standards, because they don't often mean what they say. Let's go through some of the questions that are raised in terms of human rights standards that are mentioned. We're often told that there are no amnesties in international law. Well, I'm afraid I must disagree. The reality on the ground, as we've heard people describe during the course of the morning, is that there's massive impunity for a variety of different reasons. Firstly, if the obligation to prosecute is interpreted as being fulfilled by only the trial of senior leaders, that means that the trial of, say, 5 people in Cambodia means amnesties for everyone else. Secondly, there is a budgetary amnesty. The United Nations is only prepared to spend a certain amount on war crimes trials, and beyond that it will not go any further. That amount is limited by the budget that is available, $1 billion or 1.2 billion for the Yugoslav court, 1.2 or so, a bit more for the Rwanda court, and after that they won't go any further. You've heard a discussion, I think someone from the floor mentioned the example of outreach events that occur when one is working in countries where the tribunal is based in the country. I've done those in Sierra Leone, in Bosnia, in Cambodia, and they're very dramatic because normally it's the first time that the victims of the conflict have come face to face with the judges, the prosecutors and the defence lawyers who are going to be holding these trials. And at every single one of them, someone stands up, points to someone else in the room and says, "Are you going to prosecute that man who killed my wife?" And unfortunately, someone from the tribunal has to stand up and say, "No, we are not. I'm very sorry about that." The most dramatic example I saw of that was in Cambodia, where in the audience we had Pol Pot's brother, one of the few survivors of his family who were also killed during the events, who actually looks rather like him. And so you had a very dramatic event where you had victims accusing each other of what occurred and accusing other people in the audience, and the court having to accept that they wouldn't be prosecuting them. What is the answer to that problem? Well, the fact is it's important that there are secondary mechanisms, and I think this has to be considered very carefully. In Bosnia-Herzegovina, the decision has been made to prosecute everyone. There are approximately 10 to 12,000 criminal complaints in existence in the hands of the police for offences that may amount to war crimes committed during the conflict, and the State Court of Bosnia-Herzegovina is committed to try all of them. The State Court will probably do about 4,000 or 5,000, the others will be done at the cantonal courts at the lower level. So the answer in Bosnia is no impunity, everyone gets tried. In Rwanda, Mark Drummond knows more about this than anyone else, they had 100,000 or so people in custody, no possibility of trying them, so 10,000 or so due to be tried in proper trials within the legal system, and 90,000 or so to face Gacaca justice. That's the secondary mechanism. Sometimes a truth commission can be the secondary mechanism. In Sierra Leone, there's only been 10, 11 people tried by the tribunal. No secondary trials, and there aren't going to be any. The people who were in detention in the Patemba Road prison have since been released. And the answer there is a truth commission. That's the best that perhaps could be done in the circumstances of that country. The same for Timor, a truth commission as the secondary mechanism other than the trials to the extent that they were successful. One of the concerns is in Cambodia, where there is no proposal for a secondary mechanism. And so beyond the trials that are currently going on, whether it's against one person or possibly against 5, that will be it. And that is a real concern, allows for essentially full amnesties for everyone else other than the 1 or 5 who are tried. One of the other aspects we're told about highest international standards is that there should be no political interference in the selection of the accused, and that the selection should not be arbitrary. Well, we have to be very careful that we set a good example in the international trials to the domestic trials that we seek to support, because the reality is that there is always a bit of give and take, as we've heard this morning to some extent, about the political elements of it. We know that there's a selection that is made by who happens to be arrested first. It's happened in 3 tribunals. Tadic happened to be arrested by the Germans. Akayesu happened to be arrested by the Zambians. Doik, before the extraordinary changes in the courts of Cambodia, happened to be arrested by the United Nations, as it happens. And those 3 ended up being tried as the first trials because they happened to be in custody, rather than on a particular policy. The most dramatic example of this political interference is, again, the Khmer Rouge Tribunal, where the Prime Minister Hun Sen has made it absolutely clear that there will be no further accused other than the current 5, and if anyone tries to arrest them, he will throw the United Nations and the tribunal out of the country. The court continues to have trials and apparently is investigating further people, despite that blatant political interference, which clearly undermines the authority of the court to be independent. So we must be very careful to make sure that there is political independence, and we demonstrate that as well. Equality of arms is another phrase that is constantly used. This is getting better. In East Timor, we had a rather unpleasant experience where the first 10 trials essentially had international prosecutors paid an awful lot of money and local level defence lawyers for the first trials in East Timor, and you ended up with very poor trials that didn't meet international standards and had to be dealt with on appeal. They then changed that and brought in international defence lawyers. Same for Kosovo, international prosecutors against local defence. Same in Bosnia, except that the defence lawyers in Bosnia are quite good and they speak the same language as everyone else in the court, so they often do better than the international prosecutors. In Sierra Leone and in Cambodia, we've established the right, and in the Lebanon Tribunal statute it's explicitly there, that there must be equality, and that means that if you're going to have international prosecutors, you must have international defence. It cannot be a fair trial unless you do that. Another human rights question. Judges of the highest caliber. That's a very important one to get right, and something that hasn't yet been dealt with to a great extent yet. There have been a few attempts to recuse judges, generally based on the fact they write books declaring the accused to be guilty of the crimes which they're about to try them for, or other things such as that. But the judges must be carefully selected. Often judges are appointed who are low-level judges in their home countries, who've never dealt with the serious nature of the allegations that are facing, and their heads are often turned by the dramatics and the media attention, etc., that they find themselves in the middle of. Also, international judges often have close links to the countries who appoint them. One of the judges of the extraordinary chambers in the courts of Cambodia constantly referred to what his government told him to do. My government doesn't think we should have more than 5 accused. I normally, when talking about judges, do their accent, but if I do it for this one, I'll give away who it was, so I'm not going to do so. But it's very important that we set a proper example in the international judiciary when trying to get across in domestic war crimes trials, but these things must be done fairly. Corruption, another problem. You can't have a fair trial before a corrupt tribunal. Normally the UN has been very good on this. As soon as there was suggestions mainly in the defence for fee splits in Rwanda and elsewhere, action was taken to prevent that happening. The exception perhaps is again the Cambodia tribunal, where allegations of corruption have been half-heartedly dealt with by the United Nations, such that there's still a stain on the reputation of the tribunal as to whether or not there is in fact a criminal offence occurring throughout the administration. Defence rights. These often come up, normally referring to Article 14 of the International Covenant, but again I'm always slightly worried that they're not done in the proper way or presented effectively. The presumption of innocence. That's one that doesn't often get properly dealt with when we're dealing with war crimes cases. People are referred to as war criminals or as perpetrators before they've been charged, let alone convicted. The leading case on this in the European Court of Human Rights, Alumni de Ribemont against France from 1995, makes clear public officials, whether they're politicians, prosecutors or police, should not make statements that imply that someone is guilty before they have been convicted. I'm not sure if it applies to ex-prosecutors, but that would be a matter for some submissions to be made, perhaps. But certainly in the Charles Taylor case, you had the Secretary-General of the United Nations declaring him to be a war criminal before the trial had even started. That isn't acceptable, and if the United Nations doesn't get it right, how do we expect domestic trials to get it right? The second point, which I'll deal with rather more quickly, is the question of building firm foundations in the organisational ability of domestic courts, building capacity, as it's known in the jargon of the United Nations. How do you support a domestic mechanism? It's often quoted in the hybrid system that building capacity is a benefit of the tribunal, but not only will we try the 1 or 5 people in Cambodia, but we will demonstrate how to do a fair trial to everyone else. That doesn't work unless you plan it and do it properly. It isn't going to work by trickle-down, unfortunately. It's not going to work by osmosis, that by sitting next to a judge you'll suddenly learn how to do it properly. So there are important things that must be done and lessons must be learned. Judges, local judges, you've got to have a proper selection process. There has to be a lustration process of the judges first before you can move on to appointments. Bosnia, they got that right. They cleaned out the judges before trying to do war crimes trials. In Cambodia, they did it the other way around. There's never been a process to check the credentials of the judges. The payment's got to be correct. Bosnia, they were only paid about 10% more than their local judges. In Cambodia, the judges at the extraordinary chambers are paid triple, quadruple the normal salary that they would acquire, although there's little possibility for bribes in the Khmer Rouge Tribunal, so possibly there's a different way of looking at it. But it's very important that that process is done properly in the early stages of building a hybrid or domestic court. The lawyers have to be trained. One of the flaws of the Yugoslav tribunal was that there were no former Yugoslav lawyers, certainly in the organs of the tribunal, the prosecution or the judges, for many years to begin with. They were there in the defence. That, to some extent, wasn't beneficial to Yugoslavia and to the trials that were going to happen in domestic countries. There needs to be working with the Bar Association if it's possible, although that can often cause serious problems where the bar isn't necessarily independent. Training is very popular in building capacity. Unfortunately, there's little coordination, and often much of it isn't much use. Lots of Bosnian lawyers were taught how to cross-examine Texas style, but I'm not sure that that actually was an enhancement to the process in Sarajevo. There needs to be coordination. In Cambodia, the UN's been there since 93, 94, slightly earlier. No one could do a list of what training had been done before. No one had the faintest idea how many training courses there had been and who had been trained. So someone, and it probably has to be the UN, has to coordinate that in a post-conflict transitional justice situation. Court management. Sounds a bit dull, but unfortunately you need to be able to make sure that you've got a court that can actually try people for serious crimes. Unusually the United Nations likes to choose as administrators people who've never worked in a court before, which doesn't necessarily help. They got that right in the Sierra Leone court. They had an administrator who'd done courts in the UK, and in Bosnia, where they had people who knew what they were doing. But the importance is making sure it works. Two different ways of doing it. Sierra Leone in Cambodia and Bosnia are probably good comparisons. The Cambodian one was to split the administration into half, so you have Cambodian administrators and UN administrators. Some reasons to that, partially because of the concerns over corruption. But the Bosnian system is to link the foreigners and the locals together so that they actually do learn from each other. Another key thing, I'm afraid, on court management is not to follow the example of the international tribunals. Don't send the ICTY people down to build a court in a country that may not have the funds of the ICTY. Unfortunately, the tribunals do things very expensively, and it's not an effective way to build domestic courts. The worst example I've got of that is trying to put in the audio-visual systems in Cambodia, where the ICTY showed us it couldn't be done for less than $2 million, whereas we got someone from Sarajevo who did it for about 200,000. So you have to work out the best ways to do things. Lastly, on the question of building capacity, the justice system itself. And often in a post-conflict society, before you can move to trials, someone has to reform the legal system to make sure it's proper and it works in an adequate way that is strong enough to have these trials. That has to be done in a coordinated way that makes sense and not in a confused way that leads to total disorder. The worst example is probably, again, in Cambodia. We have model courts designed by the Australians. We have a criminal code designed by the French. We have a commercial code from the Japanese. We have legal aid that I think probably came from Alaska. And we have advocacy, again, from Texas. Mixing all those into a post-conflict society is not helpful. So the conclusion in terms of building capacity and the way that it must be done to build firm foundations for domestic trials where some international assistance is sought is essentially planning. Someone has got to be responsible for bringing the experience that has gone before to bear on the creation of the new hybrid court or domestic court, and that means the UN has to make sure that they maintain the memory that they built up over the last 10 to 15 years and have a unit that can be responsible for doing that. And again, non-governmental organisations perhaps need to particularly focus on this question. Whilst a few have delved into individual tribunals, there isn't really a single NGO that focuses on creation of domestic or internationalised courts. And so that is important so that we can make sure that these domestic trials work.
Thank you very much. It's great to be here. I appreciate the invitation from Georgetown and Human Rights Watch. The topic I'm going to talk about, I guess, is a little bit further up the chain in some respects, analytically, than sort of the nuts and bolts that Rupert has talked about. And that is when we think about peace and justice, there's an assumption that I think we all talk about, but without really examining it. And that is that domestic institutions are better. And I think we all agree with that, but I don't think we actually realize why that might be the case, because that's certainly a mantra that you hear a lot. And so, just very briefly, in my mind, I think there are many arguments about why you could argue that domestic solutions are better. It sort of comes down pretty easily to the fact that we think that domestic solutions are better in sort of valuing the equities of peace and justice. They calibrating them to what is needed in the locality such that whatever comes out of that resonates. Because I would argue that if it doesn't resonate, the real goal of the process, be it peace, be it justice, is not going to be internally sustainable. Unless you get a change on the ground, a change in the people who actually perpetrated, who actually were victimized, you're going to be back to the victimized, to be victimized and perpetrated again before you know it. So that, I think, is sort of that's what I want to talk about. So what does it actually mean to approach these problems, these institutions, with that in mind, with the idea that resonance locally is what you need? Well, I think the first question when you think about institutions is one I'm going to talk about very briefly is a question about whether or not courts are really the answer at all. And I think we talked a little bit about truth commissions, a little bit about amnesties or illustrations or what have you. And even though I think we can agree that in most cases, or at least in many terrible cases, courts play a very, very important role, I think it should be an open question in many cases exactly who deserves that court treatment and who doesn't. But let's say you do agree that courts are the way to go and that you need to have some sort of judicial solution being part of these institutions. What does it actually mean then to look at these institutions when you want to build them with the residents in mind, with the residents of the locality? Well, I think the first thing to realize is that whenever you go into a post-conflict situation, despite what it looks like on the ground, you're not going to go into a state of nature. There's no Hobbesian state of nature out there. In other words, there is a system in place, even if it's been decimated, even if it has been destroyed, even if there's no infrastructure there at all. There's a system and understandings and philosophies that are there that might be rather different than we, be it international community, be it Anglo-Americans, what have you, think should, quote-unquote, look like justice or look like a domestic system. So I think the first lesson really, at least from my experience, is you have to take a system, even if it's been decimated, as you find it, not as you wish it to be. And this is of a larger issue. I think Rupert mentioned a little bit. There is very much an overarching Anglo-Americanization of the international justice system, both up high, but also what people don't realize is down low. Inasmuch as the Bosnian system, for instance, the Bosnian criminal justice system, I mean, not to make fun of Alaska a lot, but it actually is based upon the Alaskan criminal code, which is kind of strange if you think about it. But why is that? Because the person who designed the criminal code of Birch Cove, this little area in Bosnia, happened to be an Alaskan bard, a lawyer, who then was called in to design the larger criminal justice system of Bosnia. Now, you can say a lot about Alaska, but it's not clear to me why that should be the justice system model that you then use for Bosnia. So I think that's something just to think about. But there are a whole sort of slew of arguments or a slew of problems of resonance that you get when you look at how the international system has actually worked or hasn't worked locally. And so I'm going to sort of go through a couple of them about sort of where you see the resonance perhaps falling apart, that when you sort of think about how to build these institutions, you need to focus on once again. The first one, I think, is what crimes are charged at all. And I think we sort of come here and we talk about the Charles Taylors and the Milosevic's, and you're right, these are horrific crimes and the war crimes, the big sort of crimes the ICC looks at, the ICTY looks at. But again, from an issue of resonance, these crimes often don't mean much. In other words, it's almost a Hannah Arendt problem. It's too big to actually sort of mean much. And so what you saw, for instance, in some cases in East Timor, is instead of prosecuting for war crimes or genocide, rather the prosecution was for mass murder. This had a domestic correlate, clearly, to this sort of international. But why was that the case? It's because it meant more to the individuals. That seems to make some sense. The other component, of course, about what crimes you charge, I think we've talked about this a little bit, is about financial crimes and the issue of corruption. Now, the identity between war criminal and war profiteer is so close in many cases that most people, or many people on the ground, when you talk to them about who should be prosecuted, they may actually have the same list of the international community, but the crimes they want to get them for are rather different, at least the order. So, for instance, the Charles Taylor situation, many people think that the way you get more support locally behind a prosecution for Charles Taylor is by making it clear to everybody that one of the reasons you, an average citizen of Sierra Leone, Liberia, or what have you, is so poor is because he has stolen everything that was yours. In other words, once you rip the sheen of this sort of heroic person off, the ability then to go after him for other crimes is significantly greater. We can talk about this a little bit later when it comes to Milosevic, but it's definitely sort of something you hear quite a lot on the ground. The second question is the one of level of perpetrators. And I think Professor Orentlicher mentioned this a little bit. But I think it's very, very important because it's true that our understanding of international systems don't necessarily or shouldn't necessarily correlate to what people on the ground really want to see happen. And so our desire to get Milosevic and Taylor, I think, is all well and good. But you ask people again in former Yugoslavia, in Sierra Leone, Rwanda, what have you, who they want to get is something that's quite different. And it might be different victim by victim, admittedly. But, for instance, I heard a lot in Africa, they want to get the person who actually did the crime. Why is the international community not getting that person? I don't feel that there will be justice until I get justice for the person who did this crime to me. That's not something that the international community has actually worked on. And, of course, in Yugoslavia is sort of more nuanced, but I often heard that what they really wanted is sort of the mid-level commanders, not necessarily the foot soldiers, not the Tadić's of the world, and perhaps not the Milosevic's, but the people who were actually in charge on the battlefield is who most people, or at least many people with whom I spoke, were interested in actually getting behind bars. Another one is the issue of ordering and timing. And there are two ways. I found this is interesting from a resident's perspective, is an issue of when to try. And, of course, there's a sort of a mantra that we've heard now for hundreds of years about, justice delayed is justice denied. But there's another side of that, and that's rush to justice. And there's this concern that when you're balancing peace and justice, there are two arguably good arguments on one side or the other. And to rush to justice in one sense may actually hurt the justice in the end. And I think that the international community is so focused on this sort of ideal, which I think is universal in a sense, but perhaps not as universal as we'd like it to be, that we forget about that. The other component of timing that I found on the ground from a resident's perspective is critical, and that's one of temporal jurisdiction. When you're building an institution, it's all well and good to say that for pragmatic reasons we need to limit the temporal jurisdiction. But what the international community has done in many ways is by limiting the temporal jurisdiction, it's left out components that that lets a lot of people feel that justice has even been done. So, for instance, ICTR perhaps is the best or the worst example of this. As many of you people in this room probably know, the region Rwanda, Burundi has been a sort of a cauldron of tension and genocides and response genocides between the Hutus and the Tutsis for generations. But, of course, the ICTR, which is providing justice, is solely looking at the genocide of 1994, which is fine from a pragmatic perspective, absolutely fine. But when it comes to resonance, the fact of the matter is that for the average Hutu, who may have had relatives who were murdered by Tutsis in the recent past, much like for the average Croat, or the average Serb, who may have had people, Serbian relatives murdered by the Croats during the 1940s, the fact that there's a temporal jurisdiction there limits the ability for them to even think justice has been done through this process. And again, a local sort of solution has a better option in sort of calibrating the pragmatics, which obviously are there, with the needs on the ground, which are often unmet because of it. Another one, of course, is justice, is judges and who are the judges. The international community has decided that the best way to provide international justice is by having judges and often prosecutors completely divorced geographically, ethnically from the ground. And that's a huge slight to many people on the ground who feel as though there are other ways to deal with this. Again, in the former Yugoslavia is a perfect example. It's not as though the Balkans were a wonderful, happy place before the 1990s. There was a lot of ethnic conflict, and the way they dealt with it often is by having multi-ethnic judicial panels. And so a Croat wouldn't be judged by a Serb, it would be judged by a Croat, a Serb, and a Bosniak, or some combination thereof. In other words, they dealt with it via inclusion rather than exclusion. And that for them was the way you sort of get a more understanding. It's sort of the local history is at any rate, is sort of a part of the story as opposed to being completely divorced in this very sort of surgical understanding of what law and justice actually is. And the last one I want to talk about briefly is the issue of process. And I know that Professor Crocker talked about plea bargaining. But what's interesting about plea bargaining is it seems like a very sort of minor process. And again, from a pragmatic perspective, a very necessary one perhaps. But it can be the difference on the ground between understanding that justice is or justice isn't. When I was in Sarajevo, I met with a whole bunch of young law students in Sarajevo, University of Sarajevo, and their big concern was about Biljana Plavšić, who was this horrific Bosnian Serb who was prosecuted under a plea bargain. And as a part of that plea bargain, she was given 11 years for horrific crimes. And for them, they said this is just not justice. What she needed to have is a punishment commensurate with the crimes, not commensurate with the practical needs of the tribunal. It's this qualitative difference versus a quantitative difference. And the fact of the matter is that for most countries outside, again, the Anglo-American system, plea bargaining is either non-existent, incredibly rare, or in cases even illegal. And so for us, the international community or whatnot, to think that this should be the solution, I think sort of forgets that, again, from a resident's perspective on the ground, that you don't necessarily get there. So very briefly, I sort of want to talk a little bit about how realistic this is. In other words, it's all fine and good to talk about the importance of residence and the importance of building domestic institutions on the ground, but how realistic actually is it when you're dealing with a post-war or a continuing war situation, as you, in many of these cases, or a situation like Rwanda where you had complete devastation? It's not easy, and I think that Rupert probably knows better than most at how difficult it is to build these sorts of institutions. But I would argue that if you look at what you have to begin with, it's probably more possible than many people think. And it's probably more possible in more cases than many people think. For instance, if you look at Croatia, during the 1990s, both before Dayton and after Dayton, there were islands of justice. There are islands of crime and islands of punishment that were made by the Croats against Croats for crimes committed against Serbs, crimes committed against Bosniak, crimes Croats committed against Croats from different factions. Was this a common practice? Absolutely not. Were there problems with some of the justice? Clearly. But there were little islands. And I think the job of the international community when it comes to buildings and institutions, because of the importance of resonance, is to find these islands, is to realize that there are no monolithic states out there. And even in sort of the de-Baathification situation in Iraq, the realization was that, wait a second, just because you were a Baathist doesn't mean that all Baathists were necessarily pro-Saddam Hussein. What you needed to do is find the people who weren't and bring them into the fold in a way, as opposed to just starting from scratch. It's, again, this sort of understanding of a Hobbesian state of nature versus the fact that we have a culture here and a situation otherwise. The other thing which I noticed, which I find very interesting, I'd love to talk about this perhaps in question and answer, is an interesting paradox. That it's all fine and good to say that it's very difficult to build domestic institutions, especially in a situation like Sudan, for instance. But what's odd about that is that until the domestic political situation is such that they're willing to cooperate, in other words, handing Bashir over to The Hague or letting them investigate or what have you, there's not going to be any justice domestically or internationally. Right? You need to have that sort of cooperation. But I would argue as soon as you cross that political Rubicon and you've decided that, okay, we're now going to cooperate, you go back to the understanding of the mantra that local is the best option, and you start wondering, okay, if that's the case, why shouldn't the locality, who is now willing from a political perspective to assist in obtaining justice, be called to charge to actually do the justice themselves? I mean, what is it doing to this country? What is it doing to the country to not have to deal with these horrific problems, but rather outsourcing them in a way that, frankly, might be rather counterproductive in the short and potentially long run? And, of course, you then have a problem with institutional development, inasmuch as if you look at the Balkans, years after Dayton's, you had a system which, I mean, audiovisual products are a very common sort of marker of how developed the justice system is. But the Croatian justice system, had no audiovisual capability for about a decade until the French government decided to pay, I don't know if it was $200,000, but some amount. And it was because all of the attention had been sucked up by the international community at that sort of expense of the locality, without really a concern for what is needed, again, from a resonance perspective. So what should the international community do? I would argue that in many cases, perhaps most cases, it needs to work to focus on these domestic institution building. The international community and international justice might have a role in that. I would argue that one of the interesting examples more recently is the Habre trial, which is going to happen in Senegal. What happened there is the international community went to Senegal, including Bruno Cathala, who at the time was the ICC registrar, and helped the government of Senegal to figure out how to have a domestic trial. In other words, build up these institutions. Should it happen in Chad? I'd prefer it happen in Chad, but certainly Senegal, I think, is better than it could be otherwise. But I think that if you really are after the resonance, which I think is, again, if you go back to what we're really after and what our sort of starting assumption is, that domestic is better, I think we need to keep that sort of through and understand that that's when you're building institutions, be it locally or, frankly, internationally, that understanding of resonance is got to be critical.
Thank you. Thank you very much to our three panelists, and I'm happy to open the floors to questions now. And while maybe people gather, let me put the first question to all three of you, maybe trying to bridge two concepts that we have discussed in this panel, which are justice, understood as criminal justice on the one hand, and the rule of law on the other. And how do we go about building the rule of law based on justice that for atrocity crimes is often extremely selective, if not one-sided? And how do we make sure that we can capitalize on the effort to foster criminal justice to actually build the rule of law in post-conflict situations? Rupert, would you like to start?
Right.
Just and in the meantime, please, if anyone has questions, if you could please get to the microphone. Thank you.
I think the job of the international community is probably to ensure that the rule of law applies as best they can by setting up the systems that work. But I think that no matter what the cultural background or the legal system or the historical aspect of a country is, everyone knows what justice is. I'll give an example. In Cambodia, there is no tradition really of adversarial trials. Same in Sierra Leone. No one has trials at all unless you happen to live in Freetown. And so no one really knows what a court was and how it operates. And so when I'd initially speak to people, they'd say, well, they're guilty. When are they going to prison? And we'd have a 20-minute discussion explaining, well, actually, we don't do it that way. We hear the two sides of the story, because to every event there are two sides of the story, and once we've listened to it, then the judges decide. And it was amazing how quickly the people of Cambodia, despite all that they've been through, utterly accepted that. And I mean, I would always be there on behalf of the defence, which isn't necessarily the best place to be in a country like Cambodia, particularly where everyone has suffered. But I never got a single sense of aggression or unpleasant response from them. I did from foreigners, but not from Cambodians. And they always seemed to understand what was meant by justice. And I think they accepted that there needed to be a process before that they would feel some form of reconciliation from that process.
I mean, I have a couple of responses. I think what we need to develop is a much more diverse and polycentric understanding of what justice is, and not necessarily sensitize populations as to what we normatively believe justice ought to be. And I think that that is one major critique. If there's a dark side, I mean, to borrow from David Kennedy, if there's a dark side to virtue in both humanitarian law and international criminal law, I believe it's that generally the conversations are, we have a monopoly on the understanding of justice and how to achieve it, and if you target afflicted populations feel differently, it's because you need to be sensitized and learn what we understand justice to mean. And I would prefer conversations that would go a little bit more two ways in that particular regard. And that's why I think it's very helpful for us to learn from case studies and kinds of combatants or kinds of accused, I'll take your caution, accused perpetrators that we just treat very, very differently, right? And I think that's why the DDR example is a good one. I think one point, Adam, that you made that is very interesting is, and I corroborate through my work with victims as to what victims often understand retributive justice to mean in terms of righting the balance. And actually, a lot of victims view it as a greater retributive imbalance that their neighbor, let's say, that they knew for 20 years, suddenly was caught up in political extremism and murdered their own family members, for example. In the case of child soldiers, it's very tricky, but many individuals who have been victimized by child soldiers comprehend that a child soldier is both a victim and a perpetrator. However, there is often something collectively retributively terrifying about a society in which, for example, 13 and 15 and 16-year-olds suddenly are wielding enormous amounts of power and upending social hierarchies, right? So I think we need to be very careful about our constructions of who is the most responsible and who is the most deserving of justice, because I don't think they necessarily percolate through. Now, we can never afford to do the justice that we do at the international level at the national level. It's not possible. So I think truly understanding a robust instantiation of justice, we have to go beyond concerns over due process, I think, to concerns over process. And maybe we ought to be much more welcoming of alternate modalities of justice and conceptualize those within a framework that doesn't view them with suspicion or trepidation, but instead might suggest that our ideas of objective international justice are really not that clear-cut to start off with. And a final point on this, piggying back to something that happened this morning that I thought was fascinating. The machinery of international criminal law we view as sort of neutral, universal, all-encompassing, and intrinsically generative of better times. But what's very interesting to me that surfaced in this morning's conversation is how individuals, personalities, the one person can make such a big difference, which suggests to me that the machinery of international criminal justice is not a preordained treadmill that just leads to better results. It's idiosyncratic, and people really, really matter, and I think we just need to recognize that.
Just real quick, I find it interesting talking about these issues of justice. If you go back to Nuremberg, for instance, there was another component that they talked about perhaps as often as justice, and that was sort of this understanding of never again. And I query whether or not those are the same or whether there's some distinction there. In my mind, just sort of thinking about from a Holocaust perspective, it would seem as though for many people, never again is perhaps not the same thing as justice. And I think the international community should at least think about whether or not what it is that we're really after. Because if never again from an internally sustainable perspective, in other words, if it is going to be true that Hutus and Tutsis will never again slaughter one another, how do you value that versus justice for X number, admittedly small number, perhaps whether it's local or domestic, international, what have you, of Hutus or Tutsis. And so I think that when we're building institutions or thinking about these things, maybe this is related, Mark, to sort of a more universalist understanding of what it is their goals are, let alone what justice is, and to sort of figure out whether or not that those two goals, whether they're compatible or not. And perhaps which should we value first if there's an ordering issue.
Thank you.
This is to any of the panelists. I'm wondering if you could talk a little bit about gacaca and what worked, what didn't work. And I'm also wondering very pragmatically if you have any thoughts of what should have been done but also could have been done in the Rwanda case.
Yeah, sure. I've thought of gacaca quite a bit. So as you all know, gacaca for genocide is unique in that it's much more neo-traditional than actually traditional gacaca. It's formalized in national legislation. The process is much more akin to a Western criminal court to some degree than the traditional instantiation of gacaca. And I've argued elsewhere that there are three major reasons for this. One reason is pressure by international human rights activists that suggested that traditional methodologies of gacaca simply fell so far short on the due process level. And Rwanda is not oblivious or impervious to these pressures. That's one of three reasons. The second reason is a more disturbing one, which is the Rwandan government formalizing gacaca, turning it into a criminal adjudicative process, in large part for purposes of social control, which it continues to do to this date, which is an ulterior motivation for transforming gacaca that doesn't have anything to do with sort of the justice of the overall output. And that manifests itself in many, many ways. And I think it's part of a broader trend in African states and states in general to attempt to internally colonize traditional methods of dispute resolution that may very well decentralize political power away from the formal state apparatus, and clearly that's happened in Rwanda. And I've argued that the third reason why gacaca has become neo-traditional instead of traditional is, let's just be honest, it is really hard to deal with the kinds of egregious criminal acts that occurred in Rwanda. Traditional gacaca was not geared for massive levels of interpersonal violence, and the traditional institution not being geared for it, you can't just, I think, rely blithely and blindly on what happened beforehand. And in the process of modernizing gacaca, there's been a certain upshot to it. Women are much more included in the process in the neo-traditional form than in the historical form, where they weren't included at all. But I also think that there's something that has been lost. And I think one thing that has been lost is some of the redemptive value of traditional gacaca and the bottom-up ability of communities to empower themselves in their own processes of reintegration. How could it have been done differently? I mean, I've argued that a form that was less within state control and was more organic in the community would have been preferable. I think had there been more deference to the local level, we would have probably had the opportunity for more conversations about something that Adam lamented, namely in the Rwandan context, the absence of accountability for RPF criminality, particular war crimes. Maybe that would have been somewhat different in that particular regard. And I think we need to recognize that traditional methods of dispute resolution, the local, I believe ought to be the presumptive way to go, but you can't romanticize these institutions either. And the Rwandan government, as do many governments, have manipulated Gacaca for their own purposes. That said, and on this I'll conclude, you know, you can make these kinds of critical assessments of Gacaca, but there's one point that is really clear, and Gacaca is now basically done. The Rwandan government estimates that 1.1 million people have gone through it. That may be on the large side. Others have suggested 400,000, 500,000, 600,000. Let me tell you something. In a short period of time, Rwanda has done more transitional justice than nearly any other place. And for those who believe that that's a good thing, I do think, to some degree, that also needs to be recognized. But I think Gacaca is illustrative of many of the problems, but still, at the end of the day, it was much closer to ordinary Rwandans than the ICTR, and certainly much closer than universal jurisdiction trials abroad.
I mean, it's always dangerous to play sort of counter history about what could have done in the wake of the atrocities of April '94, but I think one of the things I get upset about when it comes to sort of thinking that through is that it's true that things were absolutely decimated. Depending who you ask, there were either 9 lawyers or 15 lawyers in the country. I mean, it was pretty amazing how much was actually just completely leveled. But I still think there was a potential to focus on the domestic then, perhaps especially then, because even though you still didn't have a state of nature that I talk about, it was pretty close. And there were attempts, there was thought that Kagame asked people to come in and sort of help work on the Constitution, to help devise perhaps a system where justice could have been done. Admittedly, it would have been difficult. There were obviously tens of thousands of potential perpetrators. But the problem, of course, then is that because that didn't happen, and the Rwandan government, in a sense, was sort of pushed into accepting the ICTR, you have the very unfortunate fact that the only country ever to vote against a tribunal, a UN tribunal, is Rwanda when it was sitting on the Security Council, and it was against its own tribunal. And if that's sort of not a sense of sort of an issue of resonance, I mean, I don't know what is. And so for me, it's not clear that it would have worked to focus on the domestic. But I'm very upset that there wasn't even really an attempt financially, intellectually, that the Rwandans were given that space.
I'll abuse my duty as a chair to just intervene just very briefly on that, having worked for 6 years on Rwandan issue at the International Tribunal for Rwanda, and very shortly after the genocide from 1995 to 2002. I think that we cannot ignore the truth-telling impact that Gacaca has had. I fully agree with what both of you have actually said in terms of issues with due process and difficulties with the modalities. But the truth-telling has actually taken place through Gacaca trials, through weeks and weeks and weeks of, by the way, obligatory participation in Gacaca. We often forget that, which is that it is not something that people choose to go and attend. It is an obligation under Rwanda's law for anyone in a given, village to actually go and attend Gacaca sessions. But that compulsory truth-telling, as limited as it is, has certainly helped some form of stability. Whether or not it's lasting is another issue. Yes?
Thank you for the very thought-provoking presentations. We've heard a lot about the preference for domestic justice mechanisms, and are also aware of the expense of ad hoc international tribunals and all of the challenges in determining how they will be structured and bringing together the international community from a variety of different systems. So with that in mind, my question is, to what extent is the collective learning from the transitional justice processes in these post-conflict situations and these situations of extreme international criminal activity, to what extent is that learning being harnessed and being utilized to inform the way the international community approaches international development in the justice sector, in the rule of law sector, on more of a day-to-day basis in peacetime situations in developing countries? countries. So, for instance, is everything that we've learned in setting up the ICTY and the ICTR and the Special Court for Sierra Leone, is that somehow analyzed and communicated to UNDP to inform the way UNDP does rule of law development work, or even to other national governments that are heavily involved in rule of law development, or to the international NGOs that are so involved? And also, if we do recognize that domestic justice mechanisms are the first preference, to what extent does the total budget picture reflect that or not? So is the money being spent that would need to be spent so that these countries could have a chance at having the type of criminal justice system in place that could handle, a Joseph Kony or a similar war criminal? So to sum it up, I guess what I'm wondering is, are those who specialize in international criminal law and transitional justice actually trying to work themselves out of a job in the big picture? Any thoughts on that? Thank you.
Excellent question for this panel. Which one of you would like to take it? Rupert, who has systematically worked his way through just making sure that you don't have a job and then move to the next one.
I mean, oddly enough, there isn't, in my experience, much connection between the rule of law development community and the war crimes community. Possibly the reason is that people who work in war crimes tribunals tend to be trial lawyers, and they like to stand up and ask questions and things like that, and they're not particularly good at administration and planning and filling in forms that would be required. It's a different form, often rule of law, but I think there is a crossover, and I suspect, to be honest, as the tribunals start to shut down, there's going to be a bit of a market for lawyers who've worked in these tribunals. I'm not being entirely flippant. There really are a lot of people with a lot of experience at these courts who will not have any other courts to go to because they're all shutting down within the next 3 or 4 years, save for the residual mechanism that will have to exist. So I think there could be some crossover, and I think it's important because I think quite often the rule of law movement, particularly when it's sort of parceled out to corporations or management consultants to do, often lacks a practical element to it. And I think there is quite a lot of experience that could come from the human rights movement to assist with that. In terms of the budgets, they're normally incomparable. I used to have all the figures in my head, but sadly I don't anymore. But certainly one of them for Cambodia, I think the annual budget for justice in the whole country, judges, courts, defence lawyers, everyone, is $1 million a year, whereas the tribunal has probably run up about 100 million already. It was certainly running at about 30 to 40 million a year. So the sums of money are completely different. And it always comes up in the national discussions because people realise huge amounts being spent on small amounts of trials, and that causes a lot of bitterness. So I think that is a flaw of the system. They're not cheap. If you're going to have them, you've got to pay for them, international trials. But I think as we move to the pressure for domestic trials, the cost of them will have to be examined more carefully.
On that question, the total budget for Gacaca so far has been about roughly $5 million, and I mean, enormous numbers of people have gone through it. And Priscilla Hayner had estimated that in Mozambique, to reintegrate former fighters who committed systematic war crimes through traditional modalities, it was about $2,000 U.S. person for reintegration, and it worked, right? Obviously, you all know the ICTR budget has been well over $1 billion. I don't think you can disaggregate the funding from any kind of conversation about what justice is. So that pushes us, I think, to ask the following question, right? Which is, why are we willing to give so much money to international criminal tribunals who prosecute such a tiny sliver of people and often do so in a very bloated manner? And I think the answers to those questions are somewhat troubling. I think the narrative of international criminal trials are always presented as this heroic struggle of people who care against the apathy, cruelty, and indifference of states. But that's not true. States generally support international criminal justice institutions, and they put money there, and I think there's a few reasons for that. And one is it's easy. Secondly, it's a very thin sliver of truth-telling and justice, lots of other structural factors, historical factors, international complicity, all of that is submerged in a story that's never told. And I think we just need to be somewhat more honest on that. Can I say one final little thing about the gacaca that I think is fascinating? And this is something that I worry about with gacaca as well. In the most recent documentary on it by Anne Adjian, this sort of French-American filmmaker, there's this one scene where there's this one woman who had suffered terribly, and one of the goals of state-run gacaca in Rwanda is to promote reconciliation. And it's often done quite forcibly. You have state officials that are reconciliation facilitators who go into communities. And in this one vignette, this woman did not really want to reconcile with the offender. And you can understand why. A victim, one of the only things that she has or he has after being aggrieved is the power to withhold forgiveness. And for a perpetrator who's been told that getting that forgiveness is the essential element of redemption, catharsis. There's a very evangelical quality to some degree to gacaca. To be denied that. So at the end of the day, the reconciliation becomes about the perpetrator's redemption and not necessarily the victim's suffering. So I think these are very important things that we can't necessarily romanticize about these methods. And to me, gacaca did truth tell, but I also think what it does to some degree is it can coerce the victim into giving up about the only thing they may have, the power of judgment.
Very valid and profound point indeed, yeah. And it's back to then what is really truth-telling.
Exactly.
But let's take the two last questions and then wrap up.
I think both at various points, Adam and Rupert had kind of made the comparison that the internationalized court in Sarajevo was possibly the best answer of all of the various models that are going. And yet it should be noted that while the international community generally agrees with that the state political organs in Bosnia itself were more than willing to let that whole thing unravel earlier this year by not expanding the law dealing with the international staff, and that it was not until the very loud intervention of the international community and the Office of the High Rep essentially overriding the Bosnian Council of Ministers that process continues. So while it's looked at internationally successfully, certainly the host country that's dealing with the issue was more than willing to let that fly. Any comments?
I think the problem with that one is that the people who are objecting to the Court of Bosnia-Herzegovina also object to Bosnia-Herzegovina, and they want the country to cease to exist. So Bosnia has to deal with a fundamental question as to whether it continues to go forward, and it has to reform its constitution. The European Court of Human Rights has required it to do so. A post-conflict constitution is no longer acceptable 10 years later, and the court is being used as a sort of whipping boy for those who oppose the system to target. And the foreigners should have gone a couple of years ago. It's taken longer than expected for them to leave, so I think they've become less popular than they were to begin with. So I think the system is accepted by many people in Bosnia, but there's a large minority who are vociferously against it. But nevertheless, I would maintain the position that that's the best example of internationalized justice that we've seen.
Yeah, I think I would agree. I mean, Rupert's right. I mean, the sunset provision should have actually already come into being. And it's true that it almost collapsed. It's true. But it didn't. And so I think my argument at any rate is that it's not as though countries like Bosnia-Herzegovina, Rwanda, Sierra Leone can do this on their own. There needs to be some official international assistance or multinational assistance. The question is where's the comparative advantage there? And if the comparative advantage in Bosnia-Herzegovina is to twist some arms in some cases, then so be it. I mean, I think that in some respects, I would agree with Rupert. It has the best of, frankly, of all that we've learned on the ground. And if I may very quickly just talk about the money issue again, I mean, the bang for the buck for Bosnia-Herzegovina court is pretty amazing. The statistics I heard when I was there is that for $16 million, they got the building, which is a nice building in Sarajevo, and 18 months to 2 years of actual operations, 16 million US. ICTY, when I was looking at it, it was something like 300 million a month. Is that right?
3 million a month.
Is it 3 million a month for ICTY?
I'd say so.
Anyway, the difference, as you can see, for 2 years versus versus not, it's pretty significant. And the other thing which I think is important from the perspective of justice is that without that, money is finite, and the inability to then use some of that money to build the justice, be it a state court of Bosnia-Herzegovina or overhaul their justice system or what have you, is taken out because that money just isn't there. So I think it's actually related to the justice issue perhaps in more ways than we would like to think.
Yes, please.
Thank you so much for our panelists. I really would like to thank you in particular because your discussion have addressed a lot of concern that I was thinking about, because you provide like a different side or talk about the issue from different angle, and it touches different method that it may be like proposed for certain cases. And I just have a question about if you could advise in the case of Sudan in particular, as currently like the only method that is available and in place is the ICC, which so many people criticize, but we believe it's important because we don't have any capacity at national level. And I would say for our national system to just prosecute one crime, they need to work for 20 years at least, this with a hope. Because of so many, like even judges become perpetrator currently in the current. And what it make it harder also that some people that are working on Sudan, they think peace agreement or election may change, but the same people who committed crime, headed by al-Bashir, all of those home running for election, except with exception of Yasser Arman, they are all committed crime whether in Darfur or in South Sudan or within the Sudan. And this is a very hard reality for us as a Sudanese. Then what method that can complement each other, at least if you can advise in the case of Sudan and make this information available for those home working on Sudan, because it's really critical, and I don't see that the local currently is promising or giving any hope, because we have a fear about the proposed MBK panel report that talking about the hybrid, and given the fact about if you talk about hybrid African court, we have so many African countries who supported al-Bashir and other Arab countries that within the regional context we don't have trust that justice will be served even if there is a hybrid African court. Then it's really critical to hear from you. Thank you so much.
Thank you.
It's a tough question. I mean, I think sort of going back to my the drum I beat all the time, I think that the truth of the matter is that justice is not going to happen in Sudan, domestically or internationally, until there's a political decision to do that. And that's interesting because I heard Prosecutor Ocampo speak a few weeks ago just before the snow, and he was in Washington, and he made the point that people asked him, how do you think you're going to get your indictees? And he said, well, it's different depending on the case. So for Coney, for instance, he says that the way I foresee him being delivered to The Hague is as a result of some sort of special operations force, military dropping in to northern Uganda, what have you, and secret him out. Whereas for Bashir, he said that the way I foresee him coming is as the result of a political change in Sudan. And for me, that was interesting because, unfortunately, the question then becomes, when is that change going to happen? But then if the change does happen, the argument then becomes one of, well, if there's a political change that's so great that they're willing to deposit their head of state in The Hague, one has to question why Sudan itself is not now capable, with perhaps some help or some pushing, some arm twisting, to do the prosecution themselves. So it's not a very positive line, at least sort of the way I look at it. I mean, until there's a change in Sudan, there's not going to be justice, I think, domestically or internationally. But as soon as that change does happen, which I hope is sooner rather than later, and I also hope that the ICC isn't stopping that change from happening, but that's a different argument, then I think we can see some movement forward, but perhaps not until then.
I mean, I do think one thing that international criminal trials do well, or prosecutions, is this sort of expressive function of communicating to a global audience that some bad things are happening. Now, for the Sudanese, that communication may be irrelevant. I mean, certainly for the Rwandans to have the rest of the world know that a genocide occurred, well, that's very nice, but we knew that already. So, but, I mean, there is value in that, and I do think that that is happening in the Sudanese context to some degree. I mean, but a second point, briefly, that I would also wonder, if the purpose of the process of the indictments is to weaken leadership of the indictees within the country, you can't always take it as a given that the people who replace are necessarily better. It's possible they could be worse. And I think that's a very live possibility in this particular context, and I think an honest conversation we should have as well, because opponents may seize on a weakened leader who is tarnished by international indictment, but those opponents are not necessarily always forces for better.
I think I'd agree that the real question for Sudan is that it needs time, and there is an appropriate time when the factors come together to make a tribunal of some sort possible. Different conflicts, it's taken different periods of time. In Bosnia, it took 10 years before they could do domestic trials. In Latin America, it sort of has taken 15 to 20 years for the human rights courts to intervene and then move on to criminal trials. In East Timor, they probably tried it too early, which is why the earlier trials weren't successful, but the proposal for follow-up trials now may be more successful. And of course, in the case of Cambodia, it took 30 years before it was possible to have a process for what occurred in the 1970s. So I think there will come a time when the political will is there, and if the court systems are strong enough. As I understand it, Sudan has pretty robust court systems. Certainly the commercial courts were modernized with international assistance about 5 or 8 years ago, and so there would be the capacity there to do it if the will was there as well. There is, of course, the other option, which is the regional mechanism. The African Union has decided to add a war crimes or a criminal jurisdiction to the African Court of Human and People's Rights and Rule of Law and Crime, but the reality is that will take a lot of time as well, as the court hasn't yet got its human rights jurisdiction up, let alone the commercial jurisdiction, let alone a war crimes jurisdiction, which is completely different. So I think it will still be time for that one as well.
So on this note, having highlighted so many of the challenges that we undoubtedly facing in trying to further criminal justice, I would like you to please thank our panelists again. Thank you.
I think it worked. You're right. It was very diffuse. Hi.
Presentation. I'm very much aligned with David Kennedy.
Oh, really? I shouldn't talk so much. There's definitely maybe not a dark side, but that would make a difference. Someone that's a I used to know because that's not and that's the one
Or ran the water, so.
Robertson, I was thinking out of this earlier, trying to saying something similar to me. Or should have been.
I'm looking at a failing, a facing crowd. I know.
Right, no, but I think that's great. Right.
No problem.
Hey.
Good to see you.
Great. Yeah. How are you?
Fine.
Good.
So,
Congratulations.
Bit of a cold.
Well, congratulations on your appointment.
Thank you.
How's that all coming along?
It's going fine. I mean, it's all sorts of six international trips so far.
It's exhausting.
Yeah, enjoy.
You sound okay.
I sound okay, but
are you all dry?
Dry. Yeah. Let me make sure I get a bottle of water here.
We got one right here.
Excellent. Perfect. Wonderful. Let's hope we have a few folks that
you will.
Appreciate
absolutely.
Your contributions to this. Easy for me to sing the song.
So where's your next trip planned?
Well, aside from all the ASP, I mean, I've got the Rome Code this weekend to try to negotiate the crime of aggression, and then on to the Assembly of States Parties adjourned session to try to tee up Kampala if possible. And then Cambodia and probably Sri Lanka.
Yeah, I'm on the advisory panel to some Council on Foreign Relations project.
Well, that's the panel?
Yeah.
John and...
Yes, and that's right.
Who's the other fellow?
Waxman.
Right.
Yeah, and it's interesting because it is interesting because I think what is happening, and it must be very difficult for someone in your position of leadership, having done so much ICL, to balance the normative international criminal law discussion about what, for example, the crime ought to be, with the political interests and jurisdictional interests, right, of the United States, which are really, they ought to be, like, do you understand? We make two different questions, but they can't, right?
They can't be. No, indeed.
Is my observation
No,
fair?
it's true. I mean, it's certainly easy to find common ground on complementarity.
But this is a tricky one.
But this is a tricky one, except for the fact that, it's not like the ICC is prosecuting collateral damage or prosecuting good friends of ours.
Well, I agree with you.
Exactly. But so it's the focus is on
but that's why we're lucky.
Crime.
But that's why we're lucky that it's great that you're in this position of leadership. Because I just think you're going to have a more, I can't just think of the right word, just look at it through a couple of different lenses. Is that fair?
Yeah, that's fair. Let's see what you think after you stay, stay for these remarks.
Right, exactly.
More of the Pollyanna here.
Yeah, well, I doubt that. Anyway, thank you.
Should we bring people?
Yes, bring people to the table.
Okay. Hi, if everyone could please come back in and take your seats so we could get started with our keynote address, that would be terrific. Before I start introducing our keynote speaker today, I just wanted to extend my thanks on behalf of Georgetown Law's Human Rights Institute and Human Rights Watch to all of the speakers at today's conference. They've given us a tremendous amount of food for thought, and I really hope that we all can continue these conversations in the months ahead. I also wanted to invite all of you to stick around after our keynote address and after Sarah Darashori of Human Rights Watch says a few closing remarks for a brief wine and cheese reception that we'll have here in this room. And with that out of the way, it's now my great pleasure to introduce to you our keynote speaker, U.S. Ambassador at Large for War Crimes Issues, Stephen Rapp. We're honored to have Ambassador Rapp with us here at Georgetown to share his insights on the difficult and important topic that we've been grappling with all day, the challenges of balancing peace and justice. Ambassador Rapp's office, which reports directly to the Secretary of State and is often referred to by what I think is its very catchy acronym, SWCI, is responsible for developing United States policy response when atrocities are committed against civilians, both in areas of conflict and elsewhere around the world. His team works to support the courts and tribunals that bring perpetrators of war crimes to justice in places such as the former Yugoslavia, Rwanda, Sierra Leone, Cambodia, and Iraq. Although the United States is not a member of the International Criminal Court, his office also works on issues related to the ICC, and Ambassador Rapp himself led the first ever U.S. delegation to the Court's annual Assembly of State Parties late last year. But Ambassador Rapp and his staff do much more than just work with existing international and hybrid tribunals. SWCI also works with governments seeking to address international crimes in national justice systems and focuses not only on prosecutions after the fact, but also on strategies for preventing atrocities before they occur. Ambassador Rapp, who took up his post last September, comes to his position with a wealth of experience on these issues. Most recently, he served for 2.5 years as prosecutor of the Special Court for Sierra Leone, where he left a lasting mark. Among other notable accomplishments, he led the effort to prosecute former Liberian President Charles Taylor. And his office won several groundbreaking convictions for sexual slavery and forced marriage as crimes against humanity, and for the recruitment and use of child soldiers as a war crime. Before joining the Special Court for Sierra Leone, Ambassador Rapp served for 6 years at the International Criminal Tribunal for Rwanda, where, as chief of prosecutions, he oversaw the trials of the individuals responsible for planning and directing the 1994 Rwandan genocide. Before that, as one of the ICTR's senior trial attorneys, he led the prosecution team that won what was known as the media trial, the first convictions for using mass media to incite genocide. Back stateside, Ambassador Rapp has served as a U.S. Attorney in the Northern District of Iowa, as staff director and counsel at the Senate Judiciary Committee, and as an elected member of the Iowa legislature. When we began planning this conference many months ago, and we thought about who we wanted to serve as our keynote speaker, we immediately identified Ambassador Rapp as our first choice. We could think of absolutely no one who was in a better position to speak to the vexing issues that we've been discussing all day today, and we're honored that he's taken the time to be with us to share his insights into these subjects. With that, let me turn this over now to Ambassador Rapp, who I should note has kindly agreed to take some questions from the audience after his remarks. Thank you so much.
Thank you. Thank you very much, Rachel, and Sarah. Thank you, Georgetown Law School. Thank you, Human Rights Watch, for making this conference possible. It's been an outstanding program. I made a point of, I didn't get here quite at the beginning. I think I got here at 10:30. But if I was going to keynote, I wanted to be at least able to hear the tunes that were sung, in the hope that afterwards I could perhaps harmonize them. I'm not sure that I can, but I think I can give a perspective. First of all, excuse my voice. The great thing about being ambassador at large is that you get to travel a lot. 6 international trips so far, many overnight flights on planes, dealing with the problems of international justice in real terms. I wanted to talk about something that I think those that care about peace and justice, those in this room, those that have presented, I think, share in common, which is that what this is all about is the protection of the innocent, of civilian populations, preventing them from being targeted for murder, for rape, for mutilation, or other deprivations. The opportunity to do that and to use the law to perhaps accomplish it is what drew me to prosecution at the federal level in our own country, and as an international prosecutor in Rwanda at the and for Sierra Leone, and to the current job where I'm a diplomat for the first time in my life, but also a diplomat whose job it is to try to make accountability possible, to try to reserve a space for justice, which can include prosecution. I remember when I first came to Arusha, which is now almost 9 years ago, and was parachuted into the media trial, which was then in its 7th month, and spent time with my fellow prosecutors and defense attorneys as well, and spent those days, day after day in court, looking across the courtroom at the individuals that we sought to have convicted for the crime of crimes. I thought hard about who they were and why they had done the acts that we alleged that they had done. The defense told us that they were reasonable human beings who had simply lost control, that the forces of ethnic hate had been so strong that once a beloved president was shot out of the sky, there was a rampage of spontaneous violence, a rampage that went on for 100 nights and 100 days for 14 weeks and resulted in the murder and sometimes the painful deaths of 800,000 human beings, a rate of killing that exceeded that of the Nazi death machine at its most efficient. That characterization of what happened in Rwanda did not square with my experience. Certainly, mobs do run amok, but their energy dissipates without leaders to provoke and to provision them, to direct them to their victims, and provide the means to break through those walls and that stiff resolve by which groups and individuals protect themselves from painful injury and death. As I studied the Rwanda genocide, certainly the facts in one prefecture alone put the lie to that spontaneous anger theory. And those were the events in Butare, when by April 19th, 13 days into the genocide, were 100,000 Rwandans, approximately, maybe more, were dead in other parts of the country. No one was yet dead in Butare. No one was yet angry enough to raise the machete to kill their neighbor. I took the government, the constituted government, the government that Bagosora and others had organized, with many formerly supposedly moderate Southerners, to go to Butare, and for President Sindikadabwo to give that famous speech about the work that needed to be done, the necessity of getting out of the way, because so many good workers were prepared to work for their country. Indeed, by the evening of that speech, by the evening after that speech, students were being killed in their dormitories and patients in the university hospital. And within barely 2 weeks, the number dead in Butare itself had exceeded 100,000. There was another view that I heard, and it's one sort of popular in prosecution, hyperbole, and that was that we were dealing with evil that had been let loose on the world. As they said, there were no demons left in hell. They'd all been let loose in Rwanda. But these men were reasonable appearing, and a large majority of those charged in Arusha had studied in North America and Europe. Indeed, I was looking across the floor at Ferdinand Nahimana, who owned a degree with distinction, a doctorate from the University of Paris. And as I later took on the task of seeking testimony of insiders, the kind of testimony with which it's difficult to convict those at the high level who keep their distance from the carnage, I spent long hours, long days, indeed long weeks, with several individuals who'd served at the senior level in organizations responsible, without question, for the Rwandan genocide. In my view, one cannot ask a trier of fact to give credit to any witness who may have committed, in particular, discreditable acts, unless you began to understand how that witness thought and how they were motivated, until that witness was prepared to describe that to those judges. What I determined is that men did indeed commit evil acts, and sometimes during the night, the dark nights, when the rules that they had caused to be inverted, the rules of loving thy neighbor becoming the rule of kill thy neighbor, that those rules sometimes took their natural course, and then acts were sometimes committed with sadism and cruelty. But the path that they chose was one taken by rational choice. Back when I was a U.S. attorney, when I remember discussing in front of a public group why a particular crime had become so common, in this case it was a particularly profitable form of fraud, I quoted the gangster Willie Sutton, who had explained why he robbed banks. I think you probably know why, because he said, that's where the money is. Well, atrocities are committed because they accomplish an end. And the decision to undertake that strategy is a result of conscious choice. It is a strategy that works. Of course, like the fraud, and as some of the panelists have argued, money is part of it. But it also involves gaining and retaining power, gaining control over governments and institutions and militaries and minerals. Rwanda was a clear example of that, and it didn't begin in 1994. Those of you who know the history of Rwanda will remember that in 1959, before independence, there was a sudden reversal of power in that state through the pre-colonial period for as far back as anyone records it, and certainly during the colonial period under the Germans and Belgians up until 1959, the Tutsi majority had been dominant, directly ruling or indirectly ruling, a minority perhaps of 15% of the population. That was reversed in 1959, and that reversal was aided by a campaign of crimes that we later saw in the Balkans, crimes of ethnic cleansing, crimes that involve burning and looting and killing and raping, but leaving an exit path, forcing people to abandon what they've built, forcing them to run essentially for their lives. and that had resulted, after 1959 and into the early years of the 60s, into the abandonment of their homes and their positions of power in Rwanda by close to 500,000 Tutsis. The most important event that I remember looking at from the pre-genocidal period was in Gikongoro in Christmas 1963, when just a few days earlier, on the 20th of December, some of those refugees attempted to come back. Only really 200. They freed some others from a prison. They launched a rather inept and ineffective operation that was stopped in Bugesera at the bridge over the Nyer. The reaction of the government at the time was, of course, to accuse and arrest and send many Tutsis into jail. But the reaction in Gikongoro was the most interesting. In Gikongoro, the local officials with national sponsorship organized squads to murder civilians. Not just a handful, not just 100, not 1,000, but more than 10,000. Perhaps many say as many as 14,000. The act at the time was referred to by Bertrand Russell as the most horrible and systematic massacre that had happened in the world since the extermination of the Jews by the Nazis. President Kayibanda publicly blamed the Tutsi invaders for provoking the unrest, which his government, in fact, to the extent that unrest meant massacre, had sponsored. And he said that it had all been a warning to those who resist the wisdom of democracy, which became a slogan, democracy, republic, used again during the genocide to refer to control by the Hutu majority with total disregard for the rights of the minority. Of course, an attack from outsiders, from the refugees, occurred again in 1990 with much more effectiveness by Paul Kagame, leading the RPF, of whom it was said that he had been allowed to leave Rwanda on his mother's back because of that ethnic cleansing campaign. Children and women had not been targeted, had been free to leave. And in asking the question, what should be done now, the best example, certainly, of the propaganda as it built and as the plan built was that famous cover that we cited so often in court in the media trial of Kengura number 26, published in December 1991. Kengura, which its slogan was a voice to awaken the majority people, in other words, the Hutu majority. The question asked is, what arms do we need to triumph over the Inyenzi and Tutsi once and for all? And the picture was of the machete and of Kayibanda. Of course, after that, there were many massacres in 92 and 93. And what characterized all of them is what characterized the events in 1963. There was no accountability. There was no significant international pressure, certainly commissions led by our late friend Alison DeForge, but a message that largely fell on deaf ears, to such an extent that when the choice was whether to share power or to go to total war, to essentially follow the strategy of making sure that there would be no Tutsis left to form a base for that invading army, that the hostages would indeed die if that effort to invade Rwanda continued, one had the commission, a rational decision, to commit the Rwanda genocide. I remember one statement of a witness. It's relative to Felice Kabuga, who, according to our evidence, remains safe in Kenya, protected by those whose protection he buys. One time in June of 1994, when the Rwandan government had been forced into exile well, not into exile yet, but close to exile, forced into exile from Kigali and from Gitarama, finally to the Meridian Hotel in Gisenyi, when one local moderate official, who perhaps had blood even on his own hands, came up to Felice Kabuga and said, "Have you had enough killing yet, Felician? Have you had enough killing?" And he said, his response was, "You don't understand it. We have to do this. We're doing it for our children." A rational decision. But not to make it sound like the decision there was a reflection of any particular ethnic group. The same thing in a different form had happened in a reverse war in Burundi in 1972 with profound repercussions on Rwanda. At that time, there had been a group of the Hutu elite. And if people know Burundi, you'll know that there wasn't the transfer from Tutsi to Hutu domination in 1959. A Tutsi elite, admittedly only a 15% minority of the population, maintained an authoritarian control. In 1972, a group of Hutus in the south attempted an insurrection. It was suppressed, and thereafter began a conscious campaign to destroy, hard for a 15% group to destroy an 85% group, but to destroy at least the head, the elite, the future that could in some way threaten Hutu domination in Burundi. The military decided to kill its own Hutu, 750 officers put to death. The Hutu officials of the government, including the cabinet minister, murdered, then moved to the gendarmerie, killing every Hutu who was a gendarme in the country. Next in line were the Hutu students and teachers in secondary and technical schools. By June of 1972, approximately 45% of the primary school teachers and near the totality of secondary school teachers were reported missing. Out of 700 students enrolled at the Athénée of Bujumbura, at least 300 disappeared, and by the late in the year, 200,000 Hutus were dead. And the control by that minority remained essentially undisturbed for a generation. Sierra Leone, we've heard a lot about, and I've spent an enormous amount of my time there. And we've heard about the Lomé Amnesty and the Lomé Peace Agreement. The perspective that I've always had is a reflection of the time that I spent with the victims in Sierra Leone, who described the horrendous events of 1998 and 1999, of operations with names like No Living Thing and Operation Spare No Soul, culminating, at least in world visibility, in the attack on Freetown in January of 99, a capital city in which nuns were raped in their convents, and human beings were hacked to pieces, and then often hacked in ways that allowed them to survive without means, the loss of their arms, the loss of their legs, the loss of their lips, the loss of their ears, the loss of their eyes. And though an intervention force, ECOMOG intervention force, forced the RUF and their AFRC allies out of Freetown, they still controlled 2/3 of the country. And so a peace was negotiated at Lomé in July, in which, and we've talked about that final clause, which may or may not have been part of the agreement itself, but it was a UN reservation, in which the peace agreement involved a demand by the RUF and those that had been hacking off hands and limbs, that had killed, mutilated thousands, murdered tens of thousands, and been involved in the sexual violations of hundreds of thousands, to demand a total amnesty for those crimes. And that's what they got. At least at that time, there was no perception that there would be, whatever the UN might have tagged at the end of the peace agreement, any kind of accountability. And, of course, in that particular situation, it didn't lead to peace. The rebels killed fewer, but they continued their campaigns of rape. By the following year, in May of 2000, in refusing to disarm, they'd killed UN peacekeepers and taken 500 hostage, fired into grounds of peaceful demonstrators in in Freetown who were marching up Spur Road, and it was necessary to provide a tougher UN force, a smaller British intervention, which finally defeated the rebels and forced them to surrender power that they had over 2/3 of the country, and that also included, as we've heard, a provision for a special court that would deal with those that bore the greatest responsibility for these crimes. Just one more example, of course, of how these atrocities lead to benefits that people think that justify them. We have, of course, the famous quote from Ober Salzberg on August 22nd, 1939. In our family, we have a rule, and I'm going to break it, which is that whenever anybody uses Hitler in an argument, they automatically lose that argument, because, as we all think, this is something so exceptional. But we've heard, and others I know have quoted the last line of what he said to the commanders at Ober Salzberg on August 22nd, 1939, before launching the invasion of Poland. But just to read a little bit more of it. As he said, our strength consists in our speed and in our brutality. Genghis Khan led millions of women and children to slaughter with premeditation and a happy heart. History sees him solely the founder of a state. Our war aim does not consist in reaching certain lines, but in the physical destruction of the enemy. Accordingly, I have placed my death head formation in readiness, for present only in the east, with orders to them to send to death mercilessly and without compassion men, women, and children of Polish derivation and language. Only thus shall we gain the living space that we need. Who, after all, speaks today of the annihilation of the Armenians? These crimes are committed for a purpose. The desire for Lebensraum, for wealth, for power, for control. They involve a calculation of gains. Also, I would submit a calculation of the risk of bad consequences. With more ordinary crimes in our national system, we pass laws and enforce them. We commit investigative and prosecution resources. For the banks, where the money is, the FBI and the U.S. attorneys probably give disproportionate attention. Robberies do happen, but given the thousands of bank branches in every neighborhood, they're rare indeed. When people commit crimes closer to those that we see at the international level, when individuals take hostages and threaten the innocents with violent death, unless their demands are met, we send professionals, negotiators, to make contact, to talk, and to talk, and to talk, and when they talk, to say things that are true, that it will be better for everyone, including the hostage taker, if he drops his weapons and surrenders. We don't promise to share power with a hostage taker in the community, not to do anything to put even more persons at risk, like springing cohorts or former cohorts from jail, or giving him a plane or car to get away. We do not even promise immunity if he will just let his victims live. Now, many will say this works at the national level in well-developed states where there's a system of justice to catch killers or attempted killers and bring them to trial and protect the rest of us from becoming victims. And at the international level, killers are protected by armies and by paramilitaries. They're safe in impenetrable jungles or safe behind fortress-like walls of their compounds or mansions. And if we want them to stop their crimes, we have to deal. Well, I say, yes, we should talk to them. We should engage. We should engage with what we've heard described as the bottom dwellers, We should talk and state the reasons for giving up power over their victims, and that that's good as a solution rather than carrying on as they had before. But not to promise escape that would put other victims at risk. In that land where they have committed crimes against their victims, or in another place where a potential perpetrator is watching closely. There is, as we've discussed today, an emerging system of accountability for international crimes, built in The Hague, and in Arusha, and in Freetown, and Sarajevo, and Phnom Penh, and particularly at the national level as well. There's an expectation among victims that the day will come when they'll see justice, no matter what country they're located in. And we know how difficult it is to pursue justice when individuals are dug in, when they're in positions of power. But we've seen, as Arry told us, that the international pressure, the clear statement that these crimes should have consequences, that justice is indispensable, isolates those individuals, makes them dispensable, makes others more likely to consider rule without them. As I would contest one comment said earlier, makes the others that might succeed them, bloody as their past may have been, less likely to follow the same path in the future. It offers us a new calculation for those perpetrators. Now, all of this is a work in progress, very fragile. It's strengthened when any country or group of countries condition aid or economic integration on cooperation with international justice or on genuine investigations of abuses at home. And it's weakened by any perception that accountability for serious violations is negotiable. We've heard today of the challenges in practice. We know that the most active international courts are completing their work. We know the difficulties of capacity and will at the national level where the crimes were committed. And though we didn't discuss it much, the complications of long-distance national investigations in countries where the alleged perpetrators may have sought safe haven. A strategy of no negotiation on the issue of forgiveness for violations of international humanitarian law may make it more difficult to negotiate peace agreements with those who commit atrocities. But it does, indeed, and in the process, I should say. It's a communication that needs to be made and understood. The goalposts shouldn't be moved. A lie shouldn't be told. The truth is, some crimes are just too serious for them. There needs to be, as Louise Arbour said, a space in the future for justice. This approach offers the best hope, at the end of the day, that there will be fewer who see the commission of atrocities as the path to power. Thank you very much. So, questions? Or we go to the wine and cheese.
Thank you, Ambassador. Ambassador, in the introductions there was mention that the United States now has attained observer status with the Assembly of State Parties for the ICC. Can you give us an update as to the relationship between the U.S. and the ICC? And second, where you expect this relationship to go?
Well, I think it's, first of all, clear from the statements that we made publicly that this administration has been engaged in a review of our our policy toward the ICC, and that was reflected already by our decision to take up observer status, something to which we were entitled by reason of our participation at Rome in the Assembly of States Parties, and the session that happened in November, and the adjourned session that will occur in New York in March, and in the review conference to be convened in Kampala on May 31st. And we'll participate as observers in the debate. Of course, we'll have no vote. The approach that we're taking is to state our position on a number of issues, but to listen respectfully to people that have been involved in debates in the ICC for the last 8 years when we've not been present. And we'll be active on the floor to the extent that an observer can be in New York and on at Kampala. There are issues of the crime of aggression, which I'll let somebody else ask me about, on which we have very, very clear views, but in which we're willing to listen and consider proposals that are being offered. We also want to be involved in the stock-taking exercise, which sounds boring, but we think is quite important. And as there have been discussions today about international justice and its cost and inefficiencies, we all know that the International Criminal Court, now in its 7th year and having spent not quite $1 billion, is now in the course of 2 trials. And I admire the work of the prosecutor's office, and I don't want to cast any negative light on anyone, but the institution needs to become many times more effective, if it is even to be effective as the ad hoc tribunals were, in taking on crimes that involve genocide, war crimes, and crimes against humanity. And so that, together with the whole place of the ICC in the international system, will be a subject of stock-taking. As you know, as you probably know, there'll be discussions of complementarity, the topic today here of what can be done with national systems to improve their capacity and will to take on these cases, with state cooperation, with the protection of witnesses and their communities and other issues as well. And we want to contribute to that debate. The second part of this review, without getting into in anything that I can't talk about at this point, obviously is the question of how we might participate in the ICC otherwise. And I think it's fair to say, and certainly if you read what President Obama said during the campaign, what Secretary Clinton said, that you shouldn't anticipate a decision by this administration to move forward with seeking ratification of the Statute of Rome. But the question I think that we're dealing with at the moment is whether under our law and as a matter of policy we may be able to assist the ICC, or at least assist in some way the victims of the offenses in which it's taking on jurisdiction, consistent with our law and consistent with our policy. That decision has not yet been made, and so I can't go into any further aspects of it. But that's those 2 elements consist of our approach to the ICC at this time.
Good afternoon, Ambassador Rapp. I wondered if you had any thoughts you'd be willing to share about your recent visit to the Iraqi High Tribunal.
Well, I did visit Iraq. I'm trying to remember. It's about 2 weeks ago from a visit in East Africa, and from Addis I jumped over to Kuwait and Iraq and spent about 2.5 days. In large part, it was because I was invited to give a speech at the presidency council in regard to terrorist and financing, and which relates so much to some of the work that I'd done with Kabuga's assets and Charles Taylor's assets at the international courts, and enjoyed very much that session to meet key advisors of the presidency and to answer their questions. I also visited the tribunal, saw at least one ongoing trial, and with the judges. I think we were talking earlier today, panelists were discussing national options and the fact that national options may follow and take approaches that that at the international level people wouldn't find ideal. But if it's a process that's close to the public, if it reflects local values, if it's a process that is fundamentally fair, it's something that should be encouraged. Obviously, there have been things at the tribunal, particularly the circumstances of the execution of Saddam Hussein, that I think turned a lot of people off on that institution, perhaps unfairly. To the judges and to even to Americans who were supporting that process. Of course, the main criticism that most international institutions and international NGOs have of the Iraqi High Tribunal isn't the statute of the court, which Sharif Baziouni and others were actively involved in drafting, and which tracks rather closely the statutes of international tribunals. It's been the imposition of the death penalty. That's not an issue upon which the United States can take issue with countries having the death penalty in 37 of our states and at the federal level. But the question that I think is important is whether this court is providing accountability for people that have committed mass crimes that really do shock the universal conscience. And there were those crimes. Recently, we've had the conviction for the gas attack on Halabja, which was part of the larger Anfal campaign against the Kurds. I myself remember reading and citing the decision of the high tribunals in their conviction in the Anfal case, which is now a couple years ago, one that is now in English, which extensively quoted the jurisprudence of the ICTR, including my media trial and international decisions of the ICTY and elsewhere, and found that a genocide had in fact been committed and handed out sentences. Not all of them death, many of them sentences of life or terms of years for those responsible for that offense. I was hoping when I was there to see the verdict in the Marsh Arabs case, a crime of just of unbelievable dimension, aside from the destruction of the victims and also the destruction of a way of life, and an environmental crime that's fundamentally irreparable, removing a habitat that had supported a community and its way of life for 1,000 years, was a crime, and the overall effect of it gives cause for believing, beyond a crime against humanity, that the destruction of that group constituted a genocide. That decision is yet to be made. So I'm watching those decisions that are made. Obviously, there are sometimes questions about independence of judges that concern me, and approaches to individual cases, but sitting with the judges and discussing with them issues of genocide, crimes against humanity, of international law, I was impressed that after this conflict and after the experience of the Saddam Hussein regime, that the justice was being delivered, and I think to a great extent it is in the IHT. Yes.
Ambassador Rapp, put you on the spot a little bit. What has been your toughest assignment in public life? Talk about it a little bit.
Well, I thought the toughest. I I go back to where I was when I was describing 9 years ago, coming into the media trial at a time when the deputy prosecutor who led it had been fired by Carla Del Ponte, and the chief of prosecution that had been involved in it had left to go to East Timor. And they were a team of hardworking juniors in court, but we were in our 7th month. We needed to prove that, that the messages that had been delivered by the media did indeed constitute incitement. That was, in some ways, the easier challenge, but one that we hadn't even begun to approach at that point. We had, I think, found that there were 345 tapes of RTLM radio broadcasts that had been not recorded by the studio, but by others who had heard them over cassette player, taped them from cassette players from transistor radios. And they were imperfect, but When I arrived, people hadn't even listened to all of them. We finally determined that there were 273 that were actually RTLM broadcasts, but of that group, only 50 had been translated into either English or French, and only 10 into both languages. And we were 7 months into the trial. The chief international experts on that issue, who had written a great book in 1995 led by Pierre Chrétien, and a team of 2 Rwandans, and the French newspaper editor, Chrétien, of course, the famous scholar of the Great Lakes region and author of 1,000 Years in the Great Lakes, a director at the CMRS in Paris. They had fallen out horribly with the prosecutor. The deputy prosecutor denounced them in public. There's no way we could bring them back. I went to Paris and had to bring them back. Just trying to figure out how to compensate them, given the difficulty of the tribunals and how it could take months and months and months to get contracts approved, to get plane tickets issued, and we had so little time. That was one challenge, and eventually we were able to, with that team, by bringing them back on, to mine that record and to obtain, within a year, 30 key broadcasts that we submitted. Clearly showed incitement on an ethnic basis to destroy the Tutsi population. But that was only challenge one. The second challenge is RTLM Incorporated, or SAI, didn't exist. It wasn't accused in the case. We had individuals. We had to prove that they were in control. And little effort had been put into that task at that point. And so a trial of immense international importance that should have been investigated for 3 or 4 years with intensity. We were working on night and day, trying by whatever effort we could, consistent with the rules, to bring in the evidence. We were finally able to do that. But certainly the toughest challenge that I ever had, obviously, a bit of a cure for any Pollyanna attitude about international tribunals or things done by the international community. It's like Dr. Johnson's dog walking on his hind legs. He doesn't do it well, but if he does it at all, it's a miracle. And international institutions had never been created to conduct trials, to actually bring witnesses in, to actually get people to a place on a specific date to deal with all of the challenges that were confronted there. And eventually, I think we began to get it right. But that certainly was the hardest challenge that I've ever dealt with. After that, everything's easy. Yes.
I guess this might be somewhat of putting you on the spot. I'm not sure whether you can.
That's where I stand. Yeah, right. Okay.
As a part of the administration, or appointed by the administration, but in the spirit of I guess academic inquiry, and since I am a student at Georgetown Law, I still feel some trepidation asking this as just a first-year student. But you gave a very inspiring kind of admonition that certain crimes are so bad or certain rights are so important that they shouldn't be subject to negotiation or political calculus. Something I've been thinking about listening to all the speeches today, however, is that within our own country, certain things that we seem to have admitted were done and have admitted and prosecuted previously were humanitarian crimes or war crimes are now subject to political calculus. And I wonder how this will affect your ability to act as a fair arbiter of justice worldwide, or other representatives of the United States, to do meaningful work to prosecute people who commit horrendous crimes, when they can point back to us and say, but in your situation, perhaps some of these things were justified by political considerations.
Okay. Well, thank you for the question. And I got that question in Geneva the other day. I would be surprised if I didn't get it more often. And of course, I need to be careful in talking about things that relate to ongoing investigations and that are in the Department of Justice and not in my own department. And if you brought somebody involved in that process before you today, they would probably say nothing. And they'd be well advised. What I do say always about the strategy that I want to see the United States adopt is one in which we recognize complementarity within or without the ICC.
that our position as a country is that we'll conduct ourselves in such a way that we'll never give cause to any international court to consider admission of a case against an American citizen, because we will have done it ourselves. I'm confident that our justice system, the civilian justice system in which I serve, the military justice system, does prosecute people without fear or favor, takes on powerful committee chairmen. In a different context, once took a president of the United States to the Supreme Court and beat him 9-0 on tapes that he made privately. It's a system that is a model to the world in that respect. And I think that's a commitment that this administration is clearly made, and certainly the decision regarding what euphemistically referred to as enhanced interrogation, the memos that were by which those practices were justified. Those memos have been published, and that policy has been rejected and reversed by this administration. And I expect that to remain the policy of the United States of America in the future under whatever administration. The question of responsibility for things that happened during the last 7 years or so, when those memos were in effect, is in the hands, appropriately, of the Department of Justice, in the hands of a former colleague of mine when I was the U.S. Attorney from Iowa, and he was in D.C. before he became Deputy Attorney General, and now the Attorney General of the United States. He's had to evaluate that case. There were sort of political speculations about turning away from doing anything in that area, but the decision was made by the President that it belonged in the hands of the Attorney General. And the Attorney General has had to consider questions of, I don't know exactly what he has considered, but I suspect he would have considered issues of criminalization of legal advice of counsel defenses, the ability to prove responsibility for acts for injuries or even deaths that occurred many years ago. And those matters have all gone into the process by which some parts of that have been referred to a counsel directly under the Attorney General that's proceeding with it. And I'd submit, knowing the people involved, that that's a genuine process. Yes, next question.
Thank you, Mr. Ambassador. I just have one question about the...
A little closer.
Okay, sorry. Yeah, in relation to the case of Sudan, Darfur in particular, I know that the United States, as you mentioned, is not member state of the Rome Statute, so we understand and appreciate that. But in the case of Darfur, the case has been referred to the court by the UN Security Council, and then the United States is a member state of the UN Security Council. What is the role of the United States in that capacity to support the issue of ensuring that justice being done to the victim of genocide in Darfur? And I'm sorry to say this, but we also like hearing a lot of debate and also concern among our people that the statement made by the U.S. Special Envoy to Sudan, that part of the administration strategy to reduce U.S. responsibility toward pursuing justice in Sudan, which may not be the case, but I also would like to know what is your plan in making sure that justice for the victim of genocide in Darfur is not undermined. Thank you.
Okay. Well, thank you for that question. I think on this issue, I know there's been a difference about the ICC on several other matters, but the position of this administration is quite close to that of the past administration on the issue of Darfur, which was that justice could not be achieved at the national level, that it hadn't been achieved in what even Thabo Mbeki now identifies as really a false process, where they said they would try to do something at the national level and never did it, that it's appropriate that case have gone to the International Court, the International Criminal Court, in 2008 as former Assistant Secretary Williamson told us the United States opposed deferral of that prosecution, suggested if it would, if necessary, be the only vote against it and a veto to prevent that investigation from being delayed or stalled or stopped by Article 16. And that remains the position of our government, that process needs to go forward. Of course, we also want the comprehensive peace agreement in Sudan, which was with South Sudan, involving South Sudan, upheld. We want free elections this year. We want a fair referendum next year. We want a peace process that stops the killing in Darfur. Some hopes, though I share the pessimism of many that the agreement will be upheld, but I hope to the contrary that it will be, the recent agreement between the JEM and the government. So we'll continue that process of negotiation, trying to achieve peace. That does involve us to some extent with the government in Khartoum if we're going to accomplish that end. But at the same time, accountability is an absolute necessity, and it can't be swept off the table. Now, this is another one of these issues of sequencing and timing, where it may not be tomorrow that the individuals who committed these crimes face consequences, face justice, but it has to be at some time. And that cannot and it will not be dealt off the table. Anything else? Okay. Yeah, well, thank you very much. Really enjoyed it.
Thanks very much, Ambassador Rapp, for those really thoughtful remarks. Now, I don't want to get in the way of you and your wine and cheese, so I'm going to be really brief. But I've heard that a good conference should close with some sort of sum up, so I'm going to take a stab at it. But I'll be quick. The day began with recognition that there is increasing international acceptance of the need to prosecute the most serious crimes, and the question has shifted from if to rather when and how much. The holistic approach needs to be adopted. The range of options for the worst crimes has really narrowed as criminal accountability has become more absolute. But this does create a number of problems, including the unevenness of the landscape, as was pointed out by a couple of people, where politically powerful countries are still able to shield themselves from prosecution. This, as Professor Crocker points out, can be polarizing and used by people who are rejectionists for justice. We also heard from prosecutors who approached their prosecution decisions quite differently and described how their decisions impacted peace processes. And we heard from negotiators accustomed to dealing with odious bottom dwellers about how difficult these issues are when lives are at stake and when there might actually be deaths if an agreement is not reached. Though there did seem to be agreement that if you're going to prosecute a head of state, you really better be sure that you have the goods and the evidence. And also, as Ambassador Williamson mentioned, for courts to succeed, they need strong support from their backers. The final panel made clear that the pragmatic considerations associated with justice aren't necessarily consistent with what is needed to achieve justice on the ground. And while more support is needed for national mechanisms and better planning is absolutely necessary, there is a recognition that victims are a diverse group with a wide range of interests, and that much more study is necessary of some of the things that have been done in the past. At the end of the day, I have something in my eye, so I'm sorry here. At the end of the day, the importance of standing on the principle of justice was eloquently illustrated by Ambassador Rapp. And I'm reluctant to make any predictions after Arry Nyer's speech, but I will say that I think this will be an issue likely to
be around for some time, and that I think today's discussion was really helpful and interesting in that regard. And I appreciate you all being here and staying to the end. And I appreciate all the people who participated, and especially Rachel Taylor here, who did so much. Thanks so much.